How are you?
Good, how are you? How was your Father's Day?
Lovely.
Very good.
What did you do for your wedding? Some time together?
Yes.
Yeah.
Everybody just kind of, yes, yes. Just saw in the morning. We're all very just casual.
Yeah.
Just kind of see each other for a bit.
Nice.
Kind of
Were there any things that you working through this winter or so?
yeah. I know. Mine has a grandfather on the 12th side.
Oh, that's right.
So, yeah. Yeah. It was nice. Yes, I did kind of, last night at like 11:50, because my dad's in Australia, I'm like, oh, brown.
Where?
Because I was in Australia.
Oh, upstairs.
So I totally missed it, because it's actually, they're 17 hours ahead of us.
Oh, right, right.
So I really missed it, but I did get it up on Father's Day.
Yeah.
The only reason I thought of it was how my two sisters post like an hour before mine.
Never be too certain. No.
Okay.
Sure.
The security guard up front, I told him I was. Okay, look at it. Now I have it. I just have to say, well, it's a poor person. Flesh. And he looks at me and I go, I go, I thank you for the oh, okay. I go, do you want my license? Do you know your records? Well, I used to know a bunch of them from when I worked here. None of them are still. Turnover. They were off 12 years ago. I misplaced my clothes from Florida. Right now. Right where it's home.
That wasn't planned.
Right. I'm here.
The force is strong in this one. You can't make this up. Please tell me the camera was on.
Perfect.
And it was live streaming too.
I don't think I'll come back to Will County. It is a silly place.
What?
It's a silly place.
Oh, this is a good Monday.
Someone hold up for me, I'm ready.
1 minute. 1 minute. Ready? Excellent. Okay, the County Officers Electoral Board is hereby reconvened from the June 17th, 2020, pursuant to notice and in accordance with the Illinois Election Code as provided for under Illinois law to hear and pass on objections to nominating papers. My name is Lauren Staley-Ferry, Will County Clerk and Chair of the Will County Officers Electoral Board. Also present are members of the Electoral Board, Mr. Timothy Brophy, the Treasurer of Will County, along with public member appointed by the Acting Chief Judge of the 12th Judicial Circuit Court, Karen Stuckel. Also present is DuPage County Assistant State's Attorney Connor McCarthy, the special counsel appointed to advise the Electoral Board. The Electoral Board rules of procedure were previously adopted, and those will govern all of the Electoral Board proceedings. Legal counsel, will you please commence the proceedings on behalf of the Electoral Board?
The matter before the board is case number 2020-1 entitled Gerard v. Munoz. Richard Gerard, objector, and Richard Munoz, candidate for the office of Will County State's Attorney, to be voted upon at the November 3rd, 2020 general election. The objection alleges that the candidate is ineligible to run as a candidate for the Republican Party in the November 3rd, 2020 general election due to the candidate voting in the March 17th, 2020 Democratic primary election. On Friday, counsel for the objector filed objector's memorandum of law supporting the objection. Also on Friday, that will be marked as Exhibit Q. Also on Friday, counsel for the candidate filed candidate's memorandum of law in opposition to the objection. That will be marked as Exhibit R. Counsel, are you prepared to move forward with any witnesses that you have today?
Mr. Munoz, sir. I'm going to meet Mr. Munoz. So, for what purpose? I think I made it pretty clear. I'm going to call him as a witness. I have him on my 237 notice, as well as Mr. Pearson. So I would like to call Mr. Munoz first. And then in addition to that, I want to exclude exclude witnesses. Obviously, Mr. Munoz is a part of the objection. He'd be entitled to stay, but Mr. Pearson and any other witnesses are going to testify on behalf of the candidate. I ask that they be excluded before we begin the hearing.
I guess I object to his Rule 237 notice for violating this board's rules. Rule 12 clearly states, motions seeking interrogatory deposition or production of documents shall be permitted only with leave of the board. We were here when we set this for hearing. The objector didn't say that he needed any documents, didn't say he needed any witnesses. In fact, he said exactly the opposite. We made an objection to the constitution of the board based on bias. His reasoning, one of his reasons, this is purely a legal argument. Okay, now he wants documents in this Rule 237 production. He did not ask leave of this board to issue the Rule 237. Specifically by Rule 12, he's not permitted to issue that without leave of the board. Nor can he expand or modify his one objection, which is that Mr. Munoz voted in another primary, nor can this board on its own investigate it. So for those reasons, I think his request for a delay is not well founded.
So, counsel, I'm just asking, are you telling me that you think the Rule 237 as applies to witnesses is governed as witnesses at a hearing is governed by discovery rules?
I think this board has adopted rules. These rules are what govern. Okay? So to the extent that his 237 is requested for any documents, should be ignored and stricken.
And I think that's not an unreasonable assertion, since it does require that, but it's not asking. I don't think Mr. Piles is asking for documents right now. I think he's asking you to produce the witness listed in 237, which is not a discovery.
With regard to the witnesses, Mr. Pearson is here now. Mr. Munoz is in court. He should be here shortly. But with regard to any documents, we strongly object to the reasons stated.
Mr. Piles, are you asking for any documents right now?
No.
So I think what I'm hearing is that there's not an issue as far as the witnesses, and we can get to the other items as we go. I believe that's Mr. Munoz right there. So I think that moots the concern. Is there any objection to excluding the witnesses during the testimony phase?
No, Judge.
Okay.
Or no.
Thank you. I appreciate the increase in my status. But so as I understand it, you're not objecting to excluding witnesses, or is there anyone that you're planning on calling that Mr. Piles hasn't listed? So we know who he is.
I'm going to be calling Mr. Pearson.
Okay, so Mr. Pearson, and you said Mr. Munoz?
Yes.
Was there anybody else?
I mean, Mr. Munoz doesn't have to be excluded. He's a part.
Oh.
I understand that. I'm not asking he be excluded. but I am asking for Mr. Pearson to,
And you're not calling any other witnesses, I just want to make sure.
other than
that
Mr.
everybody out in the
Pearson
room-
and Mr. Munoz, that's correct.
You know, I would object. Mr. Pearson is a party. He's the chairperson of the Republican committee, which is one of the parties to this proceeding.
I'm sorry, Board Counsel, that's incorrect. I didn't file anything against Mr. Pearson. I'm not sure why Mr. Pearson thinks that they're entitled to representation by the mere fact that his committee filed a resolution. He is not party to this objection, and he needs to be excluded as a witness. I don't care what his lawyer, or he purports to be, to represent him in this. He doesn't have any standing in this case. Once the resolution was done, his participation in this is over. It's the candidate that files the statement of candidacy, not the committee. Therefore, he does not have any standing as a party in this case. I did not file anything against Mr. Pearson. I didn't file anything against the Will County Republican Central Committee. Mr. Pearson needs to be excluded. I intend on calling him as a witness, and the candidate intends on calling him as a witness.
And Mr. Ivick, I'm inclined to suggest the board would rule in favor of that, excluding Mr. Pearson, because I'll be honest, I've never seen a political party added as part of a hearing for a political.
This filing is not filing of Mr. Munoz. This filing is pursuant to 761. This filing is based upon the Republican Central Committee having a vacancy. That statute gives them the right. It doesn't give an individual candidate the right to choose, I want to run for office. Okay? They are a party to this. And so, again, the rules of evidence of court, we're not in court. Okay? It's these rules. These rules don't have anything about excluding a witness. Okay? And so I think it would be improper to exclude.
Mr. Ivick, sorry, I don't mean to interrupt you, but if you look at the rules, and I believe it's in Rule 12 that you cited, it says we adopt the rules pursuant to the
generally follows the rules, but they're not bound by such rules.
Yes, and I think this board does generally follow the rules which provide for exclusion of witnesses to preserve the integrity of that witness's
Yeah.
testimony.
But not if it's a party.
Mr. Ivick, do you have any case law to support the assertion that the Will County Republican Party is a properly joined party to this case?
I don't have any case law.
And my understanding is it's your position that Mr. Pearson did not have to be excluded.
Correct.
So, members of the board, I would suggest that this is a ruling that falls to you. I've tried to elucidate the issue as best I know how. Mr. Piles has asked that Mr. Pearson be excluded because Mr. Pearson is I would just say potential, an actual witness in this case. I think both parties are intending to call Mr. Pearson. The rules of evidence and the rules of the circuit generally provide that a witness may be excluded upon making a motion for exclusion of a witness. An exclusion of a witness is done so that the testimony of other witnesses doesn't impact the testimony of that witness. It's done to preserve the integrity of the procedures. Mr. Piles is asking that the witness be excluded. Mr. Pearson, Mr. Ivick's opposing that. It's my recommendation that the board move to exclude Mr. Pearson from the period of Mr. Munoz's testimony, and that would be my recommendation to the board.
Madam Chairperson, I have a
Yes.
question for counsel. By exclusion, you mean simply as a witness?
Yeah, as a witness means he just needs to step outside the courtroom for the period of Mr. Munoz's testimony.
And then he's welcome back in for the rest of the hearing?
Correct.
And that's common, sorry, no lawyers on this board. That's common procedure here, and those are generally followed rules of practice?
I would call it a routine motion in any trial proceeding that witnesses be excluded.
All right. I would so move in that case.
I'll second. Or,
Just, sorry.
yeah, go ahead.
Lauren Saley Ferry,
Aye.
Tim Brophy,
Aye.
Karen Stovall.
Aye. Any discussion? Okay, the motion carries.
Mr. Pearson, if you could please exclude yourself from the courtroom for the period of Mr. Munoz's testimony, the board would be very appreciative. Thank you.
This is about to call him now.
Mr. Pyle, are you prepared?
Mr. Munoz is my first witness.
And before we begin, I just, for the record, want to renew my objection to the presence of Ms. Ferry on the board for the same reason previously stated.
Okay, the record will reflect that you've renewed your objection, counsel.
And I want to be clear too, Board Counsel, I don't think Mr. Pearson should be here in any time where we're going to argue anything of any substance relating while the hearing is open. I don't want him to be able to couch his testimony based on an argument or something that comes up outside of when Mr. Munoz is testifying. Once the proofs are closed, obviously Mr. Pearson wants to come in after the proofs are closed and hear arguments, and he's already testified for both sides. Well, I don't have a problem with that. But if he's here while there's an argument for a directed finding, or he's here for a motion on something while Mr. Munoz is not on the stand, it's inappropriate for him to be here because he should not be able to, I mean, witnesses are excluded until after the proofs are done. They're out in the hallway. When the only time that Mr. Pearson can be in here while the proofs are going on is when he's on the stand. After the proofs are closed, I have no problem with him being here to hear the closing remarks or that. But as long as their proofs are open, I ask that Mr. Pearson be excluded, along with any other witness other than Mr. Munoz, because Mr. Munoz is a party. I ask that he be excluded. So I just want to be clear, that's my position. Not for him to be here or only be excluded when Mr. Munoz is testifying, and if there's arguments on things, he's here to hear what the lawyers and the board counsel are talking about.
Now Mr. Piles is making up new rules. Again, during the motion for the board was during Mr. Munoz's testimony, and that would be normal in any court of law.
I would point out, I think that I will point out, I think it would be inappropriate to call Mr. Pearson in rebuttal if he's returned to the room and heard additional argument. So if you're anticipating him being in rebuttal, I don't think he can come in and hear other argument that would then have him come back up on the stand. So I want to be clear, once he comes back into the room as a witness and concludes his testimony, he's done. There's no more additional ability for him to come back up. Does counsel understand that?
Understood.
Mr. Piles, do you understand that?
Yes.
Okay. I think that resolves any issues you have with the potential rebuttal witness. Okay. So those procedures out of the way, I believe we can proceed with the first witness. You said you wanted to call Mr. Munoz.
Is Mr. Pearson going to be light from the courtroom when you call him?
If this is an open meeting, so if you're prepared to call him now, I will step up.
I am. Mr. Munoz is my first witness.
Thank you, Mr. Piles. Mr. Munoz, can you please step forward? And Court, do you have any issues that you need I'm going to ask if you wouldn't mind taking a seat there. And Court, can you please issue the oath to Mr. Munoz?
Will you raise your right hand, please? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
May I pull the mask down while I talk?
I have no objection to that. I don't think you're more than 6 feet away from everybody. I'll know.
Okay.
I don't.
Oh, no, yeah.
Thanks.
Witness has been sworn.
Witness has been sworn, Mr. Piles.
Sir, can you state your name, please?
Rick Munoz, M-U-N-O-Z,
And sir, your address?
5311 White Oaks Court, Whitefield.
And how long have you been at that address?
Since October of 2018.
Sir, back on June 1st, 2020, you filed nomination papers to fill a vacancy on the Republican ballot for the 2020 general election. Is that correct?
No.
It's not. You have not filed nomination papers? Well, Board counsel, if he hasn't followed nomination papers, then I don't understand why we're here. I asked that the witness be should be directed to answer the question.
Again, if you wish just to ask my client a question, you can, but if you want to badger them and commit a speech to them, that's inappropriate.
The witness said he hadn't filed any nomination papers.
He may not like the answer, he can argue whatever he wants to argue, you can ask him whatever questions, but, this isn't a time for him to get speeches.
Mr. Piles, if the witness says he hasn't filed any nomination papers, I'm sure there's several follow-up lines of questioning you could ask on that.
Sir, did you file a statement of candidacy for the general election for 2020 to fill a vacancy on the Republican ballot for the office of State's Attorney?
No.
Sir, you're under oath. Board counsel, what exhibit number are we on? You want me to follow in along with yours?
The last one I have is Exhibit R, so you are S. If my recollection is correct. That can be to the board too, please.
Oh, well,
Any copies
got
to you?
some copies.
Thank you.
Is there a minute?
I believe that is yes. Can I approach the witness, Judge?
You may. Sorry. I
Judge,
got-
can you please, I'm going to refer to you as, you're the master judge. Take a look at Exhibit F, sir.
Yes.
Is that a statement of candidacy?
Yes.
Is that contained within that statement of candidacy? Is that a statement of candidacy for the general election to be held on November 3rd, 2020? If you could please look at that document.
It is.
Sir, there is a line for signature of candidate at the 2/3 down the page. Whose signature is that?
Mine.
Is there any signatures of any party officials on this statement of candidacy, other than Mr. Ronkowski as notary? Are there any other signatures other than yours on the statement of candidacy?
No.
Now, there was a resolution filed that indicated that there was a meeting of the Will County Republicans Committee on May 26th. Is that correct?
That sounds all right.
And how did that meeting get conducted? Is that by Zoom?
It was.
And how many people were at that meeting,
I am not
to your
sure.
knowledge?
I am not sure.
Okay. Did you attend that meeting by Zoom?
At some point, yes, I was not there from the get-go.
Okay. At some point, were you introduced to the people during this meeting?
Yes.
Did you have an opportunity to address the people via Zoom?
I did.
Was that in part to discuss your qualifications to run as a candidate on the Republican ticket in the 2020 November 3rd general election?
I suppose, I'm not sure what you mean by qualifications, but it was more of a bio,
Okay, so you were giving people your background, correct?
basically,
That includes you, where you went to law school, things like that?
and where I'm living and what I've been doing for practice.
Okay.
Yes.
So you're giving you were kind of making your case to the committeeman that they should vote for you to fill that slate, correct? Is that what you were doing at that meeting?
I was very brief. I don't think I talked more than 2 minutes.
Judge, that's not responsive to my question. Ask the court reporter to ask the question again, and ask the witness to answer the question. And the court reporter, if you would.
Question, okay, so you were interrupting yourself, you were kind of making your case to the committeemen that they should vote for you to fill that slate, correct? Is that what you were doing at the meeting?
Sir?
Not really. I mean, I was just introducing myself, so they know who I was and who they're voting for. Because it was my understanding that they had already been talking about me anyway, before I got on and prior to that. So making my case was not my job. Mr. Pearson was doing that outside of me.
Sir, going back to Exhibit S, if we could. The filing that was done on June 1st had 3 candidates, is that correct?
Presumably, I wasn't.
Is there confusion, sir, on how many candidates were on the slate?
Well, you're assuming that I was the one filing it, and you're also assuming that I read everybody else's. So I didn't.
Did you sign the petition for you? Did you sign the petition?
On my own nominating petition?
Yes. Did you sign it?
I don't think I nominated myself, but, so I'm not sure what you're asking.
I'm asking, did you sign your own petition? The petition that had the 3 candidates on it. Did you sign that?
If you have one that I signed it, then sure, I don't remember.
If you don't remember whether or not you signed your own nominating petition, I mean, that's fine. Just say, I don't remember. Is that your testimony?
At this point, I'm going to object to this line of questioning. The sole purpose of this objection is whether Mr. Munoz was voted in another primary, whether he signed a nominating petition or not, whether he, any other reasoning is just a waste of this board's time.
Board counsel, if I could, just for the record, they filed a brief in response to this and raised a whole bunch of issues that the board has now considered. And I'm asking for leeway in light of the issues raised in respondent's brief.
I'll also point out, I think Mr. Munoz opened the door when he said he didn't file any nominating petitions. I think council's appropriate in trying to find out the circumstances surrounding those petitions and the nominating papers. So I would recommend that the board not sustain any objection at this point.
Do we need to have a board vote on that?
I don't, I guess, are you making a formal request to the board?
I would make a formal request, because again, this is outside of the scope of your objection. It's not relevant whether he signed the petition or didn't sign the petition. Even if he signed the petition, your only grounds is that he voted in the other primary.
Move to deny the objection.
Second.
And I think you can conduct a voice vote on these.
Tim Brophy,
Aye.
Lauren Staley Ferry. Aye. Karen Stukle. Aye.
And that's that the court reporter read back the last question.
I'm reading back a couple of
Sure.
questions. Question, I'm asking, did you sign your own petition? The petition that had the 3 candidates on it, did you sign it? Answer, if you have one that I signed it, then sure, I don't remember. Question, if you don't remember whether you interrupting with the answer, I don't remember. Question,
Sir, is it your testimony you don't remember whether or not you signed your nominating petition?
Yes.
Okay. Going back to Exhibit S, if we could, there were 3 statements of candidacy within the filing that was done on June 1st. Is that correct?
If you say so.
I asked you to look at Exhibit S, sir.
You said you were looking at it.
Are there 3 statements of candidacy within Exhibit S?
Yes.
Okay. Now, on top, there's one for you, Rick Munoz. Is that correct?
Yes.
Who drafted this?
My recollection was Mr. Ronkowski.
Okay. Mr. Ronkowski drafted the statement of candidacy for you, correct? Is it correct?
Yes.
Okay. The other 2 statement of candidacy that are on Exhibit S are the other 2 candidates in the filing. Do you see that?
Yes.
Okay. They're different from yours. Are they not?
Yes, they're different.
The 2 statement, the page 2 and page 3 of the statement of candidacy, those are forms that are put together by the State Board of Elections. Is that not true?
They look like forms based on the numbers I see on the top with the 10 ILCS citation at the top left-hand corner. So it looks like they're probably forms.
Now, in the statement of candidacy that for Mr. and I don't want to mispronounce, is it Gutier?
Oh, Buter?
Buter? And is it Mr. Granata?
Right,
Am I pronouncing that correctly, sir?
I think so.
Okay. Their statement of candidacies were, they have a lot of different statutory sites that they refer to on there, do they not?
Again, I'm going to review my objection. Again, questioning about the legitimacy of the statement of candidacy. This objection does not question the statement of candidacy. Not at all. Okay? And so if hypothetically this statement of candidacy was completely improper, this board can't hear it. You can't amend his petition. You can't enlarge his petition. The law is very clear. It's limited to the issue raised by the objector. The validity or any errors in statement of candidacy is not an issue raised. It can't be concerned. It's not a reason to grant the objection.
Mr. Ivan, this objection is based on section 7-43 of the Electoral Code. Do you agree with that, on that?
This objection states that because of 43, and because of Mr. Munoz having voted another primary, that he should not be allowed to file a statement of candidacy. We object whether 43 covers it.
So, but it would be, section 43 brings into question the validity of the filing of the statement of candidacy, which Mr.
Not his objection. His objection doesn't do that. His objection is very narrow. His objection is one of law. His objection is because Mr. Munoz voted, he's not allowed to be a candidate pursuant to 43. Our response is 43 doesn't apply, 61 controls. Having said that, he's now trying to morph his argument, amend his argument, broaden his argument to claim that there's something wrong with the statement of candidacy. Statement of candidacy are supposed to be substantially compliant anyway, but it's not an issue for this board.
Board counsel, in my objection, I attach the statement of candidacy, and I'm asking questions relating to an objection to an exhibit that's it's contained there in the objection. I ask that the board deny his objection and allow me to continue to question the witness on something that is blatantly involved in this objection.
Whether you attach it or not is irrelevant. You don't raise it as an issue.
Members of the board, Mr. Ivick, I'm assuming you'd like a board vote on this as well. All right. The counsel for the candidate is arguing that this line of questioning doesn't relate to the objection filed by objector. I would disagree with that assertion, and I would suggest that you may want to allow Mr. Piles to continue that, although I would encourage him to get to the point of his line of question. would suggest that you file, or sorry, I would suggest that you move to deny the candidate's motion.
I'll move to deny the motion, or the, I'm sorry, the objection.
The candidate's objection to
The
the slide
candidate's
question.
most recent objection.
I'll second.
Call the roll.
Tim Brophy.
Aye.
Lauren Salifair.
Aye.
Karen Stucco. Aye.
Motion carries.
Then, Recorder, could you please read back the last question?
Question, okay, their statement of candidacy, they have a lot of different statutory sites that they refer to, do they not?
Sir?
That's a stupid question.
Okay. In fact, they refer to 7-10, 7-10.2, and section 8-8.1, and section 10-5.1. Those are, I'm accurately stating the sites that are referenced on that statement of candidacy. Sir?
Are they mentioned?
Yes.
Are they cited? No.
Are they on the top of the sheet?
They are, I told you that before.
Now, sir, it's your position. Oh, by the way, did you have any conversations with Mr. Pearson regarding your statement of candidacy?
Again, objection.
On the same terms, Ms.
Same,
Ryan?
same ground, with his discussions to anyone else about the statement of candidacy, how is that relevant to what he actually filed, and how is that relevant to the packets? There's not even an objection to the form of the statement of candidacy. It's not a basis to grant an objection. You have to amend your objection and make it another ground.
It seemed to me that Mr. Piles is discussing less about the form of the statement of candidacy than the content of it. And as I did also point out, I did encourage Mr. Piles to get to the point. Is this something that you're...
He's not getting to the point. I don't know what the point is.
Is this something that you're asking for a formal ruling from the board on?
No, I withdraw. Let's get to the point.
Can you read back the,
Question, now sir, it's your position, interrupting himself. Oh, by the way, did you have any conversations with Mr. Pearson regarding your statement of candidacy?
Sir?
Did we? Yes.
Okay, what were those, what did you talk about with Mr. Pearson regarding your statement of candidacy?
The only conversation I remember, and was just talking about the statutory, or the statutory one that was out there. And that's about the only conversation we really had about it. And that was it. After that,
Was there any conversation that a special one had to be drafted for you with Mr. Pearson?
with Mr. Pearson,
Yes.
I don't recall that I had a conversation with him about that.
You don't recall a conversation with him about the statement of candidacy, is that correct? Is that your testimony?
No.
It's not.
You asked a different question. You said whether a different one had to be drafted. I don't think I had a conversation with him about that.
All right, then let's back up then. I want to make sure, I don't want to put any words in your mouth. Did you have any conversations concerning with Mr. Pearson about needing a special statement of candidacy?
What I'm trying to think about is whether or not I had a conversation with him or some other person about that. that's why I'm hesitating, because I'm not sure who I'm talking about now.
So let me ask you a question. You're running for the office of state's attorney, is that correct? There's been papers filed for you on that, is that correct?
Yes,
And one of the duties of state's attorney is to sit on this board, is that not true?
okay, yes,
And that your office would also be advising, unless there was a conflict, your office would also be advising the electoral board on matters. Would that be fair?
yes,
Is it fair to say that you have a general knowledge of the election code? As part of your qualifications for being a candidate for state's attorney.
yes.
Okay? I want to talk a little bit about section 7-43 for a second. There was a brief that was filed on your behalf, is that correct?
By Mr. Ivick last week, yes,
Yes. Did you have an opportunity to review that brief before it was sent?
yes.
Did you make any changes to it?
I made suggestions.
Okay, that's fair enough.
Thank you. You're welcome. It's already exhibit.
I have it as Exhibit R.
This is R. May I approach the witness?
I think it's fair to say you can all approach the witness as long as you try and be as socially distant as you can, please.
Sir, would you please take a look at what's been marked as Exhibit R? Is that the brief that was filed on your behalf?
It appears that it is.
Okay. Will you please make sure that I photocopied it correctly so there's no, your best of your recollection, is that your,
Yes,
okay? Sir, I flagged a page. There's attached to your brief, there is some legislative history from House Bill 2009, is that correct?
where you flagged it, yes.
Okay, and it's your understanding, at least from reading your brief, that House Bill 2009 had an amendment that was done in 2012 to section 7-43, is that correct?
Right.
Okay. Now, you quote from this legislative history in the brief, but I want to go to your brief on the very first page. And reading from the middle, 2009 will codify some recent court decisions that have dealt with the issue of when it is and when it is not permissible to switch parties. It's a very simple basis that the courts have used, and that's the basis of this bill as well, which is to say that whenever you're between election cycles, whenever they be odd year or even year cycles, you're free to switch parties. Do you see where I'm reading from, sir? On the flagged page?
Oh, yes, I see it.
Can you please read the highlighted page, the next sentence, please?
It says, but once you have committed by voting a particular way in a primary, you're committed to do that. Be in that party in terms of a candidacy you might choose to adopt through that cycle.
Was that quoted in your brief, sir? In the body of the brief and not, was that section quoted?
No.
Oh, in your brief, it's your position that 7-61, which relates to filling vacancies on ballots, it's your position that that section needs to be read in isolation from anything else in the code. Is that kind of your position in the brief?
I guess I'll guess, because it
Okay.
looks like 743 is mostly for a primary.
Okay. And you put out a test in this brief of what a committee has to do, or what a committee, what options they have in terms of selecting a candidate under section 7-61 on page 3 of your response. Are you on page 3, sir?
Yes.
And starting in the first full paragraph, in our case, the Will County Republican Central Committee has chosen a candidate. I'm going to skip down. Beginning of paragraph 9, the statute sets forth the conditions for placing a candidate on the ballot. Is that what your brief says? Is that correct?
Yes.
And then you list out some things that are what is needed in order to place a candidate on, under 7-61. Is that correct?
Correct.
And you're also going to page 4 at the top. Your argument is that the restrictions found in 10 ILCS 7-43 should not be read into 7-61, which is the section relating to filling vacancies on the ballot. Is that correct?
Right.
Okay.
743
That's
for
fair enough.
primaries.
Now, in 7-61, there are several things in there. First condition is there can't be no name of an established party candidate printed on the primary ballot. Is that correct? Beginning number 1, that's the first thing we need to have, correct? Under 7-61, according to your brief, sir?
Yes.
Okay. And then 2, shall only be filled by a person designated by the appropriate committee. And that had occurred here. You were designated by the appropriate committee, correct?
Right.
Okay. 3, said person must file nominating petitions with the requisite number of signatures. And it says person. Person must file. That's what your brief says, correct?
That's what it says on
That's what your brief says. Correct? Under 3, said person must file nominating petitions with a requisite number of signatures within 75 days. That's what your brief says, correct?
for the third time.
Okay? Yes. Is that the only thing that gets filed under 7-61, sir? Nominating petitions?
Well, I believe the statement of candidacy also has to be filed.
That's not in the, you don't have that in your brief though, do you? Is that mentioned in the brief?
I can't hear one at a time.
Sorry.
Council, again, the Madam Court Reporter is working very hard. Try not to talk over each other.
I haven't finished my question. I'd ask that the witness be admonished to refrain from answering until I finish my question for the benefit of the court reporter.
Would you like me to
Madam Chairperson, could I remind those in attendance that you are in fact the chair of the meeting, and they should direct their questions to you as far as how the course of the meeting goes?
Amen.
Well, I'll direct you to whoever you want me to direct you to.
Direct them to the chair unless the chair asks that they be directed to me.
Going back, we're in agreement that a statement of candidacy needs to be filed as well. Is that correct? Sir?
Yes.
I'm sorry. T. Sure, showing you what's been marked as Exhibit T. Can you please flip to the second page. That, by the way, this is 7-61, is it not?
Looks like it.
Okay. Can you please read the highlighted section on page 2?
The highlighted section says.
That's correct.
The person shall file his or her nominating petitions, statements of candidacy, notice of appointment by the appropriate committee, and receipt of filing his or her statement of economic interests together.
And this is in the pertinent section of the statute that you are filling the vacancy for. Is that correct? Sir?
Yes.
Where's committee? When it comes to filing, where's the word committee? Are they filing anything, sir? Is there a committee? And what you just read, is there anything related to committee?
In that sentence?
Yes, sir.
It says committee in
The
there.
person shall file his or her nominating petitions, statements of candidacy. Is that what, that's what the person needs to file in order to be placed on the ballot. Isn't that true? Sir?
That's what the sentence says.
By the way, when you signed your statement of candidacy, were you aware of the requirements under section 10 ILCS 7-43? Were you aware of those requirements?
Was I aware of 7-43?
Yes, sir.
Yes.
And you understood it at the time that you signed your statement of candidacy, under oath.
Why do you gotta keep on saying that? I'm a lawyer. And you keep bringing my credibility into play every which way you can. Stop it.
Madam Chairperson, I asked that
Yes, I
the next thing be
Yes, I
struck and
understood
that
it.
the
One at a
witness,
time.
that the witness
Yes, I
be-
understood it.
Board, he needs to answer.
I answered it 3 times now. Yes, I understood it.
Would you like my thoughts on this, Madam Chair?
Please.
I will point out that he did answer your question, and that I asked that I think the board would appreciate, and also Madam Court Reporter would appreciate, if you were to keep from talking over each other, and also if both the candidates, who's also a witness and counsel, could lower their voices somewhat.
I apologize. Sir, in your brief, by the way, 7-61 is a section in the Illinois Election Code. Is that correct?
Yes.
And Article 7 is contained within the Election Code, and that's the article that has the section of 7-61. Is that correct?
Yes.
And Article 7 pertains to all nominations made by political parties. Would you agree with me with that?
I believe so.
Now, I apologize, I've only got a number of copies.
I'll need one for the record also.
Oh, sure,
If you're gonna, if you want it marked as.
Well, yeah, all these are marked. The ones I'm giving him, I'm going to have. There you go, sir. Exhibit U, is that a copy of 7-43?
Looks like it, yes.
Okay. Now, the header on this is qualification of voters at primary elections. Is that correct? That's what the section relates to?
Yes.
Okay. And when we look at the language, there's restrictions on people being able to vote in a primary. Is that correct? That's what the section kind of regards? Sir?
Looks like it, yes.
Okay. In the very first part, I got highlighted, no person shall be entitled to vote in a primary, then there's a colon and A, unless he declares his party affiliations as required by this article. Do you see that?
Yes, I see that.
Okay. And sir, could you please read the highlighted portion that is marked X?
A person who voted the ballot of an established political party at a general primary election may not file a statement of candidacy as a candidate of a different established political party or partisan office to be filled at the general election immediately following the general primary for which the person voted the ballot.
You voted in the 2020 primary, is that correct?
Yes.
You please state which party you chose to affiliate with in the 2020 primary.
I chose to pull the Democratic ballot.
There's been a statement of candidacy that has been filed, whether it be on your behalf or whoever, that has you listed, you have signed a statement of candidacy that you are running as a Republican candidate. Is that correct?
Yes.
In your test, I'm going to go back to your respondent's brief that's marked as R. I'm going to go back to page 3. It's your position that all the qualifications that are needed for a person to be slated by an appropriate political committee are contained within 7-61. Is that correct?
Yes.
Okay. I have an 18-year-old son who's a registered voter. Could he have been slated by the Republican Party to run as a candidate for state's attorney
No.
under 7-61?
No.
Please point out, and you have a copy of 7-61, please point out the section in 7-61 that does not allow him to run as a Republican candidate for state's attorney.
He would be qualified because he's not a lawyer.
Well, what section of 7-61 is that included in, sir? And I have a copy of the election code here. If you would, I don't want to confuse you. I'll give you any section of the code that you want. I'm just asking, wonder what section of 7-61 prevents my 18-year-old son from being slated by the Republican Party as a candidate for state's attorney?
The section of common sense. That's a stupid analogy. Again.
All right. That would be in the Illinois Constitution, wouldn't it, sir? The Illinois Constitution, Article 6, requires a state's attorney to have be licensed attorney. That's the section that does not allow him to be a candidate. Is that correct? Sir? You can take my word for it.
Yes.
Okay. Now, let me ask you this. Under what section of 7-61 would a person who's graduated from law school but has not passed the bar yet, but will pass, or has passed but won't be licensed until November of 2020, could that person have been slated as a Republican candidate for state's attorney?
I'm not sure.
Could the Republican Central Committee have slated somebody who lived in Joliet, but on the Kendall County side of Joliet. But they promised to move here if they were elected, and they would be a Will County resident by December 1st, 2020. What section of 7-61 disqualifies that person or allows that person to be slated by the Republican Central Committee?
And Chairman, again, what relevance does this have to Mr. Pyle's objection?
The argument is this, if I may. The argument is this. They say 7-61 is the only thing that's involved. We read that in isolation. We don't look at anything else in the election code or in the Constitution or anything. The only things that I have to look to are what is in 7-61. This question is relevant because it points out that we have to look at other sections of the election code in making a determination, this board needs to look at in making a determination of whether or not a person who's filed a statement of candidacy can in fact be on the ballot.
Want our vote? You want an opinion on the objection?
Please.
I move to deny the objection.
I second. Tim Brophy?
Aye.
Lauren Saleh-Perry? Aye. Karen Stucco? Aye. Motion carries.
I apologize, Madam Court Reporter. Please read the last
Oh,
question.
I have a question.
Question, okay, could, interrupting himself, could the Republican Central Committee slated somebody who lived in Joliet, but on the Kendall County side of Joliet, where they promised to move here if they were elected, and they would be a Will County resident by December 1st, 2020. Mr. Isaac interrupted again, started his objection. Mr. Powell is finishing with this question on top of that. What section of 7-61 disqualifies that person or allows that person to be slated by the Republican Central Committee?
Sir?
It's not in that section. I believe it's case law.
So is it fair to say that when we're looking at the qualifications for a candidate, we need to look outside of 761 to make a determination whether a person meets the qualifications? Is that correct? Sir?
Outside to case law, perhaps.
The answer is yes.
Sure. Yes, sorry.
Sorry. On your statement of candidacy, going back to Exhibit S, can you please refer to it again? This is your statement of candidacy. Can you please read the statement in yellow?
I'm a qualified voter of the Republican Party.
Now, is it a fair statement to say that that is a qualification, as evidenced by the statement of candidacy for you to have been slated for this office?
Yes.
Okay. Going back to the May 26th meeting, and those were Republican precinct committeemen from Will County, is that correct?
That's my understanding, yes.
And you said you were only on the Zoom call for a portion of the time, is that correct?
Correct.
Who did most of the talking, Mr. Pearson?
When I was on?
Sure.
Sure.
Okay. And I guess Mr. Pearson or anybody during this meeting, did anybody tell the precinct committeemen that were voting that you affiliated with the Democratic Party in the March 2020 primary?
I'm not sure if it happened at that time or not. 'Cause like I said, I didn't get on there right away, so it might have been happened before I got on.
Mr. Pearson would better, he'd be the better person to answer that question. Is that correct?
Yes. Did I hear that when I was on? No.
And was there a vote done while you were on?
Yes.
And during your bio, did you inform the precinct committee people that you would pull a Democratic ballot in 2020 primary?
No.
In your brief, you use as support. Can you please read the orange section of your statement of candidacy, please?
What comes directly after the yellow part,
Yes.
as evidenced by being designated, by being designated, selected, and appointed by a duly convened Will County Republican Central Committee of the Republican Party to fill a vacancy.
So there was a vote, and it was, is it a unanimous vote, sir?
Yes.
But we don't know if the precinct committee people that were voting, we don't know if they heard anything about your party affiliation from the March primary at the time that they took their vote, do we? Sir?
I can only talk about what I know.
Okay?
And did I hear it at that meeting? No. Did they know about it before that meeting? I presume so, because Mr. Pearson and I had that conversation before that meeting, so I presume he must have told them.
Mr. Pearson knew that you would pull a Democratic primary ballot in 2020 and was going to slate you as a Republican candidate for state's attorney. He knew that. Before the vote was taken on May 26th. Is that your testimony, sir?
Well, we discussed it, so since we discussed it, I can only presume he knew.
And that's fair. I just want to know what everybody's knowledge was before the Republicans slated a Democrat for running for state's attorney in the primary. And my question to you is, sir, to your knowledge, while you were on this call, that was not discussed. The fact that you voted in the March 2020 Democratic primary.
While I was on the call, the answer is no, I didn't hear that.
Sir, do you think... Oh, I'm sorry. Go ahead.
I can tell you though, it's, from everybody I've met, of the precinct committee people in person and on the Zoom call after that, they all knew about it when they talked to me about it, but they asked me about it. So I don't have any doubt that Mr. Pearson told them about it.
Can I have one moment, Madam Chairperson? So I can confer with my esteemed co-counsel. I do want to clear up one thing. What exhibit number are we on?
I think we're on B, Council.
Which one?
B is in
B?
Victor.
I only have one copy of this. Sorry. I only have one copy of this. Got it. Oh, you got other? Oh, I apologize. Thank you. Sorry. Oh, yes, I'm ready. Oh. Sir, in Exhibit R, your brief, there's a statement made, I'm going to quote it directly here. Go to the page number. Page 10, second paragraph under conclusion. Objector, a lifelong Democrat who consistently votes in Democratic primaries. Is that statement in your brief, sir? Page 10, second paragraph under conclusion.
Yes.
Okay? I've shown you Exhibit V. That's a voting record of your objector. The objector in this case, Mr. Gerard. Do you see that, please?
Yes, I see it.
Okay. Under P20, you're familiar with reviewing these documents, I'm assuming, the voting records of voters? Sir?
What's the question?
You're familiar with
Yes.
records like... under P20, primary 20, Mr. Gerard voted in the Republican primary. Did he not in 2020? Sir?
Yes, it looks like it.
So he affiliated with the Republican Party in the March primary. Is that a fair statement? Sir?
I think a fair statement is he voted in the
Okay.
primary as a Republican ballot.
I just want the record to be clear. And there are some Democratic primary polls, but it looks like Mr. Gerard also pulled a Republican ballot in the primary in 2004. Looks like he pulled a Republican ballot in the primary in 2002, and it looks like he pulled a Republican ballot in 2000. Is that what the record indicates?
Yes.
Do you stand by your statement, sir, in your brief that Mr. Gerard consistently votes in Democratic primaries? Sir?
I'd actually say yes. He voted six Democrats before he voted Republican the last time, so it's fair to bet 16 years between the two.
Have you seen your voting record, sir?
Yes, I have.
Okay. What exhibit is my objection, which has been admitted as an exhibit that has as an attachment Mr. Munoz's voting record?
I believe, are you talking about the filed objection, counsel?
Yes.
I believe that's Exhibit A.
Okay. So, and this is already an exhibit. This is Mr. Munoz's primary voting record. Please take a look at that, sir. Thank you. In your voting record, sir, you voted in the Democratic primary in 2020, is that correct?
Yes.
And you voted in the Republican primary in 2004. So you joined Mr. Gerard in 2004 in voting Republican ballot, is that correct?
Yes.
And you also joined Mr. Gerard in voting for Republican ballot in 2002, is that correct?
Yes.
Mr. Gerard's voted in 4 Republican primaries over the past 20 years, and you voted in 2. Is that a fair correlation of the voting records of both the objector and the candidate in this case, sir?
Sure. Mr. Ivick, any cross?
Thank you. If we could, though, if he's going to call him as a witness, I ask that his questioning be directed solely to questions I asked, and that they be asked as a form of a direct examination, since this is his client, and he's gonna call him as a witness, I'm assuming.
No, I'm not calling this a witness.
Okay, well then, I mean, I'm gonna object to scope. I think if he goes beyond the scope of anything, I'd ask questions about it.
Anything else you'd like to object to before I ask my first question?
No, I am through making my record. Thank you.
Thank you, members of the board. Mr. Munoz, do you consider yourself a Republican
Yes.
and lifelong Republican?
Once every.
No, I'm gonna object.
Once every.
May I make an objection? Madam Chairperson? This man voted in the 2020 Democratic primary. Under state statute and election code, he is affiliated with that party throughout this election cycle. I think the question is inappropriate, and it is contrary to the Illinois election code.
Madam Chair, is there anything I can assist you with?
I'm going to withdraw the objection.
Mr. Munoz, do you consider yourself a lifelong Republican?
Since I got out of law school, sure.
And how long ago was that, Mr. Munoz?
1995.
One of the first questions asked you by my esteemed colleague was your statement of candidacy that was filed on your behalf, correct?
Yes.
And there were some questions about whether you filed it or whether it was filed on your behalf, correct?
I remember those questions, yes.
Okay. And let me back that up slightly. This past primary, were you having any considerations of running for any office?
No.
Wasn't in your mind?
No, it wasn't.
Okay. This particular running for state's attorney right now, how did you come to that decision?
I'm going to object. It's beyond the scope of my examinations. It's irrelevant as to what his motivations were of why he was running. I didn't ask anything about that. My questions were very specific, and I asked that my objection be sustained.
So it might be helpful for Mr. Piles has made an objection as to scope. Scope in legal terminology is what is known as the type of question, the limits of the questions that were asked in a direct examination. Mr. Piles called Mr. Munoz as a witness, so his exam is what's known as a direct examination. This is now the cross-examination, and cross-examinations are limited to that which is within the scope of the direct examination. Mr. Ivick, did you have any argument?
He asked Mr. Munoz about filing the candidacy. And again, this is a preliminary question, and we can object to every single question I ask. I promise you, I will be much more succinct than Mr. Piles.
He said he didn't file a statement of candidacy, so I guess the question is irrelevant.
I have a question for Councilman. If we take action on this matter of scope, will it apply to all matters of scope?
It would, but obviously there would have to be objections as to specific questions, so there's no such thing as a blanket scope objection. It would go question by question.
I'll move to deny the objection.
I second. Tim Brophy?
Aye.
Lauren Saley-Berry?
Aye.
Karen Stockel? Aye. Motion carries.
So, Mr. Munoz, how did you get selected? Or how did you come about being selected for state's attorney?
It's a little more of a story than a simple answer. If you go for a moment.
We just want a summary. I don't
Okay.
want the whole story.
I'll try to summarize it best I can. I was having a conversation with my 15-year-old son.
Objection, hearsay.
And
Again, the rules of evidence are relaxed, it's an administrative hearing, and we will be here all day.
I would be inclined to advise the board about what hearsay is. Hearsay is when there's a statement offered for the truth of the matter asserted it's basically a statement of another, it's a third party. Mr. Piles is objecting, alleging, can you perhaps expound upon that objection?
Yes, conversations that are not taking place in court with another person are, unless they're hearsay. They're out-of-court statements asserted for the truth of the matter asserted. And I don't think that, there's other ways to talk about this other than saying, I had a conversation with.
Rule 12 of our procedures, technical objections such as relevancy and hearsay will not be entertained to exclude evidence, but may present bearing on weight afforded such evidence.
And if the board is curious, Rule 12 does say that it goes to weight, not admissibility. So what Mr. Piles is saying...
I'll withdraw.
I guess it's moved.
Mr. Moon, if you could just give us a brief summary of how you became selected.
Yes, and I need to mention that because that's really the how. I was having a conversation with my son about the lockdown that had been happening pursuant to Governor Pritzker and the laws that I've been looking at on that from the Emergency Management Act and so forth. And when we were talking, his comment was, why doesn't anybody stand up to that? The next day, I get a call from George Pearson about wanting to run for state's attorney's office, and at that point, I have both of these conversations with these two people, and all I can think of is, okay, if I don't stand up at this point, nobody will, and I just told my kid that, yeah, somebody should stand up. That's why. That's how it happened. I know it sounds stupid, but...
Mr. Muniz, with regard to the statement of candidacy, there was a slate of 3 selected, to your knowledge, correct? At that time. And these were to fill vacancies, correct?
Yes.
Your position was to be for the state's attorney of Will County, correct?
Right.
And unlike the other 2 candidates, you would be an attorney, correct?
Right.
The other 2 candidates don't have to be an attorney.
Well, they're not running for state's attorney or for the
And then,
position.
sir, for Exhibit S that was tendered to you, one of the statements of candidacies is that you're, in good standing as an attorney in the state of Illinois, correct?
Yes.
And it also states that you were selected and designated and appointed by the duly convened Will County Republican Central Committee, correct?
That's correct.
And that's all true, correct?
Yes.
At this point, I'm objecting to the leading nature of the questions. I'll let it go a little bit, but this is his witness, his client.
It's cross-examination.
I'm sorry, not in this. I conducted cross-examination under adverse examination. He should not be able to lead. He should not be able to lead his own client through testimony.
This is your witness. I'm cross-examining your witness. You know the rules, Scott.
I do. This is his client. He can't lead his own client.
Mr. Piles, are you making an objection to the board?
Yes, I'm making an objection to the board that he not be allowed to ask leading questions of his own client.
The board may find this helpful to know. Generally speaking, leading is prohibited on direct examination. It is generally accepted on cross-examination. And I will, in this instance, Mr. Ivick is engaging in cross-examination, albeit of his own client, but his client was called on direct examination by Mr. Piles.
I move to deny.
I'll withdraw.
Mr. Munoz, Mr. Piles had showed you a copy of, I guess it's Exhibit U, which was 10 ILCS 5 743. Do you have a copy of that? You?
Yes, I have.
Okay. And so he had asked you about, who's qualified, and he pointed at 743. And can I direct your attention to the very second paragraph after 18 or more years shall be entitled to vote as a primary. What's the very next line?
The following regulations shall be applicable to primaries.
Okay, and so that's regulations plural, correct?
Well, right, you use primaries as a plural,
Okay, and it says following, correct?
yes.
Okay. You're aware, sir, that the restriction that they're arguing about, which is on the very bottom, follows that line, correct?
That's correct.
Okay, and so the legislature, for whatever reason, decided to put that restriction underneath a line that says the following regulations shall be applicable to primaries. Isn't that correct?
Yes.
And sir, that's not the only place where it said primaries only, correct? Directing your attention, do you have a copy of Exhibit A, which was the objector's objection?
I thought Exhibit A was my voting record.
That was a whole packet. Do you have a whole packet?
No, I just have 2 pages.
There's also Exhibit A. That's the actual primary from 2020, correct?
Yes,
Okay, so when you hold the Democratic primary, you had to sign that document, correct?
yes, there's my signature on there.
And what is the language of what you're signing? What is it telling you the limitation of that is?
You asked me to cite what's on here?
Yeah, read what's on it.
Okay. It says, I certify that I'm registered to vote from the address on this appearance, and that I qualify to vote and have not previously voted in this election by means of vote by early voting or any other county or state.
Okay. And then is there also limiting language on that document?
For use in primary elections only.
Can you repeat that?
For use in primary elections only.
Oh, so it doesn't say for general elections, correct?
Right.
Okay. So that's consistent with 743, which says it's for the primary only. Isn't that true?
It appears to be.
Now, yeah, let's go about this I'm a qualified voter of the Republican Party. That's a true statement, correct?
Yes.
You are a qualified voter of the Republican Party. Is that true?
Yes.
Objection. He can't be a qualified voter of the Democratic primary. Under the statute, 7-43, for this election cycle, he's affiliated with the Democratic Party. In all due respect, please, can I finish for the benefit of the court reporter? With all due respect to counsel's attempting to interpret the election code, under 7-64, he has to declare a party affiliation. He is, for purposes of this election cycle, a Democrat. He cannot be a qualified voter of the Republican Party under the Illinois election code. Question is improper.
Is that an objection that you're...
Yes.
Okay. So if you could, are you objecting to that it states a conclusion, that it's speculative? What's your objection?
Relevance, a conclusion, contrary to established law.
If the board would like a little more background, there's a lot of legalese going on. Relevance means that Mr. Piles doesn't feel that this argument is relevant to, or this question or answer is relevant to the main issue at hand. On that concept, I would disagree because I think it cuts to the very heart of his argument. As to whether or not this states a legal conclusion, I think that goes as to its weight more than its admissibility. The court can take into account whatever it feels is appropriate with regards to whether or not Mr. Munoz's conclusion is correct, or perhaps those that are proposed by objector are correct. So on that basis, I would suggest that I'm not familiar with contrary to established law.
I just think the election code is very clear that you have to pick a party in a primary. And according to everything that we've talked about, at least thus far Mr. Munoz has testified to, that once you've, according to his brief, that once you vote in the primary, you are affiliated with that party throughout the election cycle.
Mr. Piles' speaking objection, I guess I would say I don't think contrary to established law is necessarily a valid evidentiary objection. So I would suggest that the board deny Mr. Piles' objection on these matters as far as the admissibility of this testimony goes, and the board can apply whatever weight it thinks is appropriate to it.
I have a question, Madam Chair. Again, the objection is in regard to which question? This question and this answer?
This question and this answer, these are not, again, these objections apply to individual questioning unless there's a broader objection to the scope of admissibility.
May we hear this question again, please, and this answer?
Question, you are a qualified voter of the Republican Party. Is that true? Answer, yes.
I think I'm going to move to deny the motion, the objection.
I'll second it.
Please call the roll.
Tim Brophy,
Aye.
Lawrence Staley-Ferry,
Aye.
Karen Stucco, aye.
Motion carries.
Thank you. Mr. Munoz, you were asked on direct about how laws are interpreted, correct?
Yes.
Okay. Generally, what's the first way of interpreting a law? What's the first thing, when you come to a law, how do you interpret it?
I'm going to object. I think that this is beyond the scope
You asked.
of questioning. I don't think it's foundational anyway.
I'm going to move to sustain.
And scope.
Move to sustain. Way too general. I want to get to the point of the question.
Second.
Call the roll.
Tim Brophy,
Aye.
Lawrence Staley-Ferry,
Aye.
Karen Stucco, aye.
Motion carries.
So the board has sustained that objection for the record. I guess, Mr.
I will ask a more specific question. Mr. Munoz, you are aware that the Supreme Court, from time to time, weighs in to tell us what laws say, correct?
Yes.
Okay. And with regard to who is, a qualified primary voter, you're aware that Housfield versus Illinois State Board of Education is a 2010 Supreme Court decision that followed Mr. Gerard's objection case cited in Gerard, correct?
Right, it's later in time.
Okay, so it's later in time and it's a more higher court. It's the Supreme Court of Illinois, correct?
Right.
Okay. And you also are aware that historically, there were 3 restrictions on who could run for office, correct?
Historically, I know there was.
And historically, there was a 2-year prohibition. You couldn't switch for 2 years historically, correct?
Right, 23 months I thought was the statutory language.
And
Objection, Judge. I don't think, or Madam Chairperson, what the law was before the amendment to 7-43 might be interesting in a law school classroom. It's not relevant to what's going on here as to what the law was. The only objection here is what the law is today and what applies. So I don't think that this question is relevant.
Mr. Files wants to be able to tell you what the law is. You can't know what the law is unless you know what it was and how it was changed. And he knows that. He knows that when the laws get changed, when the Supreme Court speaks on what the law is today, that's relevant.
And I think that's been argued in the briefs.
Any direction?
Well, in this particular instance, the questions relating to what prohibitions on candidates used to be, and versus what they are now, I would say that I don't think it exceeds the scope, and I think it's still relevant as to your interpretation to the extent the law is unclear, whether or not you feel it's unclear, as to what the law, how it ought to be interpreted today. So I would, it would be my perspective that that's a relevant question.
And I'll withdraw the objection based on board council statement.
Again, Mr. Williams, at the time of Cullerton, they had 3 general restrictions that you can't vote in the previous primary, you can't sign a petition in the previous primary, you can't have run as an opposite candidate in the previous primary, correct?
Yes, I believe that was it. I'm sorry.
And then following that, the legislature added that language that you quoted underneath, this is only for primaries, but they added that language that says that you can't have voted and you can't have run as another candidate, correct?
Right.
Okay. And then after that, the Supreme Court spoke, correct? Or I mean, just before that, the Supreme Court spoke, which was Hospital versus State Board of Elections, correct?
Sorry, I wasn't sure about the time frame about when the statute was put into effect and when the Supreme Court came out with their decision, so
Sure.
I'm not sure about that.
But House bill does directly say what are the restrictions, the remaining restrictions on what a primary qualified voter can be, correct?
I'm going to object, and when I was asking these questions, I was referring specifically to documents, and we were referencing the language in the documents, and then I was asking a question. He's quoting a case and he's asking for Mr. Munoz's subjective interpretation based on a case that's not an exhibit, hasn't been read. I mean, this seems to me to be a legal argument. Mr. Ivek wants to make these arguments, that's fine, but they don't seem to be in reference to an exhibit that's before the witness. And
I can fix that. I'm happy. What are we on?
We're on W,
TUVW, I think we are on W.
and for the record, if we hit Z, my numbering system goes to double A. If council is going to plan on introducing additional exhibits.
I know this was cited in the brief, and copies are different. Do you need another copy, Richard?
I don't have it at the ready. If you have one, I will certainly.
Madam Chair, if this would be a good time for recess, I'd suggest one.
Well, I think Mr. Ivek has a pending question. There's also technically a pending objection. I think this would be the worst possible time for the recess.
I will try and be brief.
Yeah. Oh, you want me to just look at it? Well, if you're going to reference specific language.
Mark,
Sorry, just for the record, Mr. Piles, is your objection withdrawn?
I'll withdraw the objection.
Thank you, Mr. Piles.
approaching what I cited as, I guess, respondent number letter W. This is the case of Frederick Hosfield versus Illinois State Board of Elections. Supreme Court of Illinois, document 109725, filed October 7th, 2010. Mr. Munez, on the far right side, the Supreme Court speaks about the remaining restrictions on who can be a qualified candidate. It does it not.
Sorry, I'm just trying to read it, so.
Sure. And it was highlighted for you, Mr. Munez.
Yes, because it looks like they're, yes.
Okay, so what specifically does the Supreme Court say is the law in Illinois?
Says the
Objection, as to what the law in Illinois was when Hossfield was decided, or what the law is now?
Would you like to rephrase your question, Mr.
There's been no change. Mr. Pyle seems to be the expert of what the law is when he misquotes what the Supreme Court has already spoken. If he has a case that contradicts this, he's welcome to cite something that contradicts what this says.
But there's been a statutory change to 7-43 that's taken place since Hossfield was decided.
Correct. Which was the language that was added under the paragraph that says that this applies only to primaries.
Madam Chair, Mr. McCarthy, I would like some clarification because the attorney has talked about the past and now the present, and so I would like clarification as to how this interpretation is of current law or a previous time.
So you've heard from the board. Would you like to clarify your question?
Clarify the question.
Yeah.
The Supreme Court, when it was stating what the law was, and I guess it was at this time, there was an addition that may or may not have changed it. My argument is that it didn't because legislative history said we're not changing the law. Okay, but this is what the Supreme Court says is the only available restrictions.
Well, I guess I would just cite it exactly rather than
Yes,
trying
please.
to parse it. Sorry, I lost my place. As the appellate court here correctly observed, the election code no longer contains express time limitations on party switching, and Rauschenberger did not run afoul of the only remaining restriction set forth in both Section 7-10 and 8-8 that a qualified primary elector of a party may not sign petitions for or be a candidate in the primary of more than one party.
Okay, it doesn't say that you couldn't have voted in the candidate of another party, correct?
I'm going to object. This whole deciding out pieces of this case, I'm sorry, this is legal argument. We're picking out pieces of this case. The facts are different. He's talking about a candidate, Steve Rauschenberger, who pulled a ballot in a off-year consolidated election and then attempted to file a statement of candidacy for a different party in the primary to go up to the 210 general election. This doesn't have any application to the facts in this case. He's quoting sections of the case out of context for the witness and to the board that are not accurate.
Madam Chair, I would point out, I think that this goes again as to weight and admissibility, and I think Mr. Piles will have an opportunity through argument to argue whatever interpretation maybe he has made that may be different than the witness. So again, I would point out it goes as to weight, not admissibility.
Move to deny the objection.
A second. Tim Brophy,
Aye.
Lauren Salieri,
Aye.
Karen Stokel. Motion carries. Please proceed.
Mr. Munoz,
Yes, sir.
you were asked on direct examination about the legislative debate, correct?
I was asked to read from that.
You asked to read from it. And there's two houses, correct? You have the House and you have the Senate, correct?
Yes,
So there's actually two debates, right?
I'm sure there must have been.
Okay, so you read from the Senate debate. Sir, from the House debate. Sir, with regard to that House debate, I guess when they're talking, they're saying why, correct? When they're talking about arguing why we should do it or not do it.
Later on in the debate, yes.
And sir, I'm directing you to, I guess it would be Exhibit R, it would be page 5. Are you there?
Page 5 of the brief or page?
It's page 5 of the brief.
All right.
Okay. And the quote from Representative Fortner, about halfway through when it says again, House Bill 2009, correct?
On page 5 of your reading, yes, I see the
Okay.
part that was cited.
And the sponsor of that debate, does he say that he's making new law, or what is he saying the purpose of this is for?
I'm not sure where you want me to be reading from, I'm sorry. Okay, from page 5?
From page 5.
Okay, thought you were talking about the other transcript.
No.
Part attached to it.
No, but from page 5, if it's easier for you.
Okay.
When he was talking about whether this was making new law, what does he say?
He says, again, House Bill 2009 is really nothing different than what is already the law of Illinois as established by the Illinois Supreme Court.
Okay, so the state of the law from Hausfeld was there was only 2 remaining restrictions. This legislative debate, which occurred a few months later, they're saying we're not making any new laws, we're just codifying what was there, correct?
I'm objecting to the characterization of what Hospital says about what remaining restrictions. I think that's an inappropriate question. It's calling for a legal conclusion. And it's an ultimate issue question that the board has to decide.
Again, I think it goes to wait.
So assuming the board would like a little more information about what Mr. Piles said. Mr. Piles' argument is that this is a legal, calls for a legal opinion. Typically that would preclude a layperson from offering an opinion. There are circumstances, and I believe Mr. Munoz has testified that he is an attorney, so I think it goes again as to the weight you want to assign Mr. Munoz's opinion, keeping in mind that he is the candidate, keeping in mind all those other factors that come into play with regards to Mr. Munoz being the offering testimony in this matter. I'm trying to think, I think you said a few other ones. The ultimate issue, ultimately, it's...
I understand. I'm going to withdraw.
Can you please repeat the question for the candidates?
Question, okay. So the state of Illinois law from Hallsville was there was only 2 remaining restrictions. This legislative debate, which occurred a few months later, they're saying we're not making any new laws, we're just codifying what was there, correct?
Yes.
No further questions.
Piles, anything on read?
I don't think I have anything, no.
I think the board expressed a desire for a brief comfort break. I would suggest to the board if they wanted to take such a comfort break, now would be an appropriate time to briefly recess to allow yourselves and members of the public to avail themselves of any facilities they may need to use.
Move to recess for 10 minutes?
Second.
Okay, there's a motion and a second.
All in favor say aye.
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 Before we go, I ask that counsel and his client be refrained from discussing with Mr. Pearson the sum substance of his testimony so far.
I think that's fair, Mr. Ivick. I don't suppose you have any objection to that?
No objection, as long as Mr. Piles also doesn't discuss it.
I think that's, nobody discussed with anybody anything that's, with Mr. Pearson, anything that's happened in here. Mr. Munoz, you understand that? Thank you. I think, no, I think we're done. Okay. I understand.
How long was your recess?
10.
10 minutes. 10 minutes, 10 minutes.
For people that remain in here, this is still streaming live,
Thank you.
and it'll remain that way.
So don't discuss any medical conditions or
Court counsel,
show any
Off the
source.
record, I'm running to the
I
restroom.
ask that the camera be shut off. The meeting is not going on.
That
Ask that the camera be shut off.
That camera is
during the
staying
camera
on.
while the meeting is not in session.
That camera is staying on.
I don't,
Oh, no, I'm sorry. The participant is now stating what he's gonna do with the camera. There's not a meeting going on, it has to be shut off and then record the meeting.
You'd have to ask the chairman.
He's entitled to record the meeting.
Ask the chairman of the board.
He is not the chairman.
I don't. Mr.
However-
I don't have any authority to do anything with regards to any recording in the courthouse. That's the chief judge's matters. There's nothing I can do about it.
I will voluntarily shut the microphone off so it only records the video and not the audio while we are out.
I'll be satisfied with that, thank you.
Okay.
Yes. Hold on a second. I'm gonna get a bottle of water. Would anyone like a bottle of water?
I think I will too.
I'm sorry, I have my cord refill in
They're going to get what? I'm going to get a Diet Coke. You sure? I got it otherwise.
We just be done.
Diet Coke?
Producing puts hot air in the What's that? Oh, yeah.
Good, how are you?
Maybe you heard this one, the original Dr. Fauci.
They're out of Diet Coke. Your choices are Diet Dr. Pepper or Diet Pepsi.
Dr. Pepper.
Dr. Pepper.
Thank you.
and I can't hear it right now. I apologize, but to make a clean record, I have to speak up and I'm not gonna, for me to make a record, I'm not letting it get out of control. It's
I appreciate
a mess,
you
so,
very much.
sorry.
Yeah, no, please don't apologize, please don't.
This isn't my first rodeo, and I know as crazy as it is now, my life will be even more misery when I'm going to edit this and proofreading, and that's why I'm like,
No, please, yeah.
Were there any names or anything that you
the
did?
only, yeah, I just took Scott's paper off
Thank you.
Representative Fortner. You know, it's, was it before? I just spelled O-M-M-I-C.
And this is me.
Okay, S-O-N, okay. How is it spelled? I'm sorry.
Still forgot the snacks.
We forgot to say it.
Oh, then I did spell it right, S-O-N. And then, I think I spelled it. It's an house.
Some Madam Miller forgot to take.
What else was it? And I
What?
I'm 99% sure. Thank you, sure. So I'm putting, second. So,
I'm prone to error just as any human is.
Yeah.
I certainly know the direction you're in. I will ask counsel during their arguments if they're going to cite a case to please so. Just to try and assist you.
our first day, people were
In the beginning, I was like,
say their
oh.
the words, and I'm like, I gotta go back, I was all ready to tell them, say your name, but the Lord,
Just trying to be,
yeah,
that's the game.
because I hate having to put,
Unknown person.
unidentifiable male speaker or female speaker, so,
Who was that masked man? I understand your issue, and I'm sure with all the telephonic hearings too, and telephonic depositions, that your life becomes even more difficult if you don't do that.
you know, it's becoming, I think it's gonna be the new normal for a while, doing it, and I like doing a lot better than doing just the telephone, because I can see a face and you can put a voice with a face. From our perspective, it works better. But there's a little glitch see their mouths moving, it could be late, but you don't hear anything, whereas here you hear the voices and keep up with it. So those I have to interrupt frequently sometimes, but otherwise it's been going well. And they can do shared screen, so when they have exhibits up, they can share it, they can highlight it, and so they're getting kind of tech savvy with it. Yeah.
It takes a little time.
Yeah.
I have cases, we're just moving on depths on.
Okay.
And counsel is experienced and has not quite grasped the legal concept.
Yeah.
He said, well, I guess we have to hold this case over a year until this thing's over. And I said, I want to do it by video. I want to get this thing done.
It's been fun because this season of movies. They're like, hold on a second, and like in comes their daughter, to like fix it. And we're like, hi, how you doing? How's it going? Our Dana, don't touch anything.
I'm properly admonished by my expert technology advisor not to touch anything.
But these kids, and I have the same thing with my kids. I'm like, how did you do it? Well, you gotta show me what you did. Let me write it down. They're like, where do you need to write it down, Mom? Just quick.
My mother's from Ireland, and
Okay.
they taught by rote in Ireland.
Yeah.
So you learn by writing it down
Yeah.
over and over and over again.
Yeah.
So I have given her basically detailed written instructions. She's basically stenographed every step I took with her computer. Well, the computer, by the time she's finally comfortable with it, the computer's about 5 years old, so I bought her a new computer for her birthday last week. I am the worst son in the world, apparently.
You're probably.
Because I bought her a new computer. That's an allegation. Actually, I did. I got her a touch screen.
I have the blanket in the car.
To so much more.
So you put a little microphone once you're there.
I want you to come in and I want you to organize all my pictures for me.
I have a blanket in my office and a fan.
So I looked here.
You guys lost power last
For
week,
someone
didn't
else
you?
to do that. Just I need to buy my time back. I love you.
Oh, just a blanket?
But I'm not going to.
We were down for like 3 hours.
Oh, no.
For you, I will.
Didn't even turn everything up, just wanted
Enough for you to go.
And the worst part is, I don't know where anything's at.
Yeah, no, we didn't get power until almost 7:30 that night.
Oh, wow.
I basically.
We at homework, yeah.
The office.
By the way, we're playing.
Be there.
Because their big concern is that if we don't get it on by a certain time, that's cooler that they have over there.
So much faster.
If we don't have it on, it drops. And if it drops below a certain thing, they have to.
I
have the
was
generator
gonna
go.
say, if she's phone savvy,
We finally have all the electrical ran so that they can hook up just right outside.
years ago.
But 2 or 3 years ago, we lost power for like 3 days. And it was a cluster. They had to run all the wires through our back door and into our server room. And then they're like, oh, it'll be fine. And they got this like little chain to close the door. Like, it was like that really cheap dime chain. Like, I could have broke it. And Amy went back there and she goes, watch this. She had one finger, no, she just unwrapped it off the doorknob.
Oh, right, yeah.
For years, we're going to be sitting here.
How'd you do that? She goes, how'd you get the chain off? She goes, one finger.
I'll be bold.
So we pushed enough to finally get like, to have the police there all night. Because like my server room is sitting wide open. I mean, no one wants my books. But my server room and all my computers.
That would be impossible.
Now,
Right.
my new thing is
So-
getting with the whole roof cooler.
Back to, how far back to the bigger towns like Joliet.
My parents never had cable.
Oh, we go all the way back.
When I went to the first time,
Uh-huh.
they should plan or something. And I bought them in the past fire stick because my mother is hockey obsessed. She loves watching.
What's nice is we're gonna be sending a couple books out.
Wait, Ireland, she's from, or is she from Canada?
From Ireland.
And like they seal them and all that. And what's nice is that anytime we need something,
It reminds her of her life.
all we do is make a call and they will go to that book and get us whatever we need and get it to us in like, within like 10 minutes.
You gotta digitize them while they're static.
Yeah, right now we're going back.
Actually, what's needed more than
Amazon for Amazon Prime.
digitization is
Anything that's on there that doesn't cost her anything, but watch for free. You know, she still just sits and watches the old
Do you know
movies on.
Kankakee County was still doing the books when I got elected. So I got, like, 92, I got elected in 08. So when Lori got elected in 08, we went to her first, like, meeting in Springfield. And she said something about how she still has a lady that writes in the book, and we all just kind of went. And she goes, well, that's how they've always done it.
It's true.
And it is. So that was one of the first things she changed, where she's like, I'm feeling like I'm like a total idiot, like, but I mean, she,
It's kind of nice. It's nostalgic, but it's slow.
so she updated their computer system, and she's really done wonders out there.
Did you find anybody to confirm that the chair traffic was?
Okay, you said this courthouse. It's not this courthouse. No, it says it was in the old courthouse. Said Nancy said, wait a minute, this was Nancy's answer.
Oh my gosh, we're back on this.
I'm not gonna date myself. This is
It's
cold.
courthouse
And
on Jefferson Street, right around the corner from the clerk's office, in the same second floor.
I don't know if it was in.
The old courthouse, this is not
I
the old courthouse.
know what he said in English, and he's just like.
She meant this one.
Second floor?
But I always remember Nancy's office over there.
But it was just, I was just like, I don't care, I didn't know what I opened it for notes, I was just like.
I got the old quarters on the book, and I said,
Yeah,
so we're
and
not,
I
she's
worked
not
on
this
it.
one.
Really got to get that one for Roxanne and both work there.
Roxanne. So,
Slow.
Attorneys are here.
John, turn the mic on.
That chair's
Sorry.
rough.
I'm gonna sit still.
I think
Is it making the record?
reconvene the meeting. I think everybody's here. Perhaps not.
Morning, council, Mr. Isaac's going to be here, so he's in the next witness.
Okay. Time to go back on the record and reconvene here.
Do I need to wait for Mr.
He's here.
Okay. Okay, great. Okay, I'll go ahead and reconvene the hearing. Back from recess. Counselors,
So just as the board may recall, we finished with the first witness to appear, and Mr. Piles, I believe he indicated he was going to call his second witness.
Yeah, the objector calls Mr. George Pearson.
And just for the record, everyone, if you're going to be using a name on either of a case or an individual, for Madam Court Reporter, if you wouldn't mind spelling it, there's Smith, Smythe, and a few different other ways it can be spelled, just to help clear up the record for it.
Will you raise your right hand, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Before council, I have the exhibits for Mr. Munoz, I think, or maybe put them back down here.
I can't really see, I'm sorry.
Yes. I'll take these. May I inquire? Madam Chairperson? Yes? Sir, can you state your name, please?
George Pearson, P-E-A-R-S,
And your address, sir?
5108 West Roberts Ridge Road, Monee, Illinois, 60449.
You are
604, I'm sorry.
You are the duly elected chairman of the Will County Republican Central Committee?
Yes,
How long have you been in that capacity?
A little over 2 years now.
Sir, on May 26th, you convened a meeting of the Will County Republican Central Committee, is that correct?
The Will County Republican Central Committee, yes.
Okay. Purpose of that meeting was to slate candidates for vacancies in the ballot, is that correct?
Yes.
And at that, how was that meeting conducted?
On Zoom.
Zoom? How many people were there?
Originally, probably between, I guess, online, 40 to 60 in and out. And there were a handful of folks that were in the office with me, about 10 or so there.
Was there minutes done that recorded the votes?
Yes.
With regard to the candidate, Rick Munoz, did you discuss at any time during this meeting qualifications of Mr. Munoz to be slated as a Republican candidate to fill a vacancy on the ballot for the Republican Party in the November 3rd, 2020 general election?
Did I discuss his qualifications?
With
Probably
the,
in
with the
general.
people, with your precinct committee people, did you discuss his
In general.
qualifications? Okay, just so you know, there's a court report here. Gotta wait till I'm done. I'm gonna wait till you finish your answer, because otherwise she's gonna get mad, and then he's gonna get mad. None of us want board council or Madam Chairperson to be mad at us, so, okay? If you would just please try to do that. So, now, in discussing the qualifications, did you have an opportunity to review the brief that was filed by Mr. Ivick?
Yes.
On behalf, you did? Did you read it?
Most of it, yes.
Okay. And the vote for Mr. Munoz was unanimous, is that correct? So I understand what's in the brief, that the vote for him was unanimous? Yes?
Yes.
And were you aware before that Zoom meeting that Mr. Munoz had affiliated with the Democratic Party in the March 2020 primary?
Objection.
Mr. Ivey, what's your objection?
It's irrelevant to the issue before this court, whether the Republican Party or Mr. Pearson was aware or not aware, whether they believe that Mr. Kyle's strange legal theories are true or not. The issue before this board is whether the fact that Mr. Munoz voted in the prior primary, which he admitted that he did, is disqualified. And so now he wants to go into the inner workings of the Republican Party. He wants to have discussions about what they knew, what they didn't know, all those different things. It would be just as inappropriate if we were doing the same on the Democratic side.
Madam Chair, if I could just inquire of board council briefly. Mr. Piles, where are we going here?
The respondent's brief talks about unanimous vote, committee made the filing, Republican Central Committee has rights. This is just going into the underlying basis for the statement of candidacy that the objection is relating to, and I'm in part asking questions about issues that were raised in respondent's brief that I think are pertinent and relevant.
I'll just to the board my thoughts on the matter of this objection. I incline to think that this area can be fraught with peril if Mr. Piles seeks to go too far beyond the perimeter of what was in the pleadings. I would suggest the board permit him to inquire down this line, but that Mr. Piles be judicious about where he's trying to direct his questioning and keep it on point as much as possible. That would be my suggestion for how the board would deal with that objection.
I'll move to deny the objection.
Okay. Second.
Tim Brophy,
Aye.
Lauren Saley-Fair,
Aye.
Karen Stukel,
Aye. Motion carries.
Question, okay. Are you aware that, sorry. Question, and were you aware in that Zoom meeting that Mr. Munoz had affiliated with the Democratic Party? Interruption by Mr. Ivan's objection. Finishing the question, in the March 2020 primaries.
Sir?
Yes.
At this meeting on Zoom with your precinct committee people, did you inform them at that meeting that he had voted a Democratic ballot in the March 2020 primary?
Again, objection.
I guess, Mr. Piles, do you have a response?
Again, I'm responding to issues that were raised about unanimous, we're denying voters' rights, all those arguments made in respondent's brief. I'm going to the sum and substance of the meeting and the petitions, and what's the statements that are made on the statement of candidacy, as evidenced by and I'm going to quote in the resolution, and they may have talked about it, as evidenced by being designated, selected, and appointed by a duly convened Will County Republican Central Committee of the Republican Party.
Again, this is beyond his petition. His petition says the sole issue is whether or not Mr. Munoz, having voted, can be on the ballot. And it's the same thing in his brief, that the sole issue is that. What the inner workings of why they chose one candidate over another, they're relevant to that issue.
I guess my question for Mr. Piles here is, how does this add to what your inquiry is? Because you've got testimony, as far as I recall, that Mr. Munoz was aware that he pulled the Democratic ballot. You've got testimony just now.
Can the witness be excused while we're discussing this? Because while we're talking about this, he's thinking.
I would, based upon this, I would advise that as to the inquiries about what the committee knew, you're asking whether he discussed it with the committee, Mr. Powell?
Yes, as evidenced by the selected and duly appointed committee of the Republican Central Committee, as outlined in the statement of candidacy that is attached to my objection.
Again, you didn't challenge the selection. You only challenged whether he can legally hold that position.
If you read respondent's brief, they were suggesting that I'm somehow, or we're somehow subverting voters' rights.
You are.
Okay then. He's just made my point for me. I asked him, are you withdrawing your objection?
No.
Based upon that, I think that since it's in response to the arguments in the respondent's memorandum of law and support, I think it would be appropriate to move forward with the question. But again, I'll suggest the board would want to consider this, that this is getting closer and closer to inquiring into the political decision-making of a party, and that's would beyond the scope of this hearing. You should be cognizant of that, Mr. Piles, again, as you would proceed, providing the board either sustains or overrules the objection.
Move to deny the objection.
Second.
Tim Brophy,
Aye.
Lauren Staley Fury,
Aye.
Karen Stupel,
Aye. Motion carries.
You remember the question, sir?
I do.
Can you back or read it back, please?
Question, at this meeting on Zoom with your precinct committee people, did you inform them at that meeting that he had voted a Democratic ballot in the March 2020 primary?
Sir?
At that meeting, no.
So before the people voted on Mr. Munoz to be a candidate, they were unaware of this, correct?
No.
So how did... Was there another meeting of your committee to discuss this before May 26th?
And again, I will renew my objection. They can't broaden the.
You know what, I'm going to withdraw the question. I'm going to withdraw the question. And there was a vote taken at that meeting, correct?
Yes.
And you discussed the qualifications of Mr. Munoz at that meeting, correct?
In general, yes.
Did you discuss his Republican voting record at that meeting?
Again, I would object.
It seems like the witness is looking at Mr. Ivick. Can I ask that the witness not be taking cues from candidate's lawyer? I mean, he looked at him like he was waiting for an objection. Can the witness be instructed to answer my question?
Again, the objection is very simple. Your sole issue, according to you, is a legal issue, that he voted and that he's not legally qualified. You keep on trying to ask about the inner working of the Republican Party. It's irrelevant. You know, if you didn't attack the selection, you didn't say the selection was improper because they didn't know X, Y, or Z. You didn't say that. You can't amend it. You can't expand it. And we can go here all day if you try and see what they said about their positions. I don't know why you're afraid of the Republican slating the candidate.
If they hadn't put the phrase in this, as Mr. Gronkowski drafted this, if he hadn't put this extra language that is not found in the state board form of the statement of candidacy, we draw something special, and it says, as evidenced by being designated, selected, and appointed by a duly convened Republican Central Committee of the Republican Party to fill a vacancy. They put into issue in the statement of candidacy, and it's already been referenced in testimony by Mr. Munoz about this meeting process. I think I'm entitled to see what kind of meeting process is being referenced in this statement of candidacy by Mr. Munoz.
So, just to help advise the board, the question here relates to the meeting at which Mr. Munoz was slated, and inquires as to whether or not they discussed the voting record of Mr. Munoz. I think that ties sufficiently back to the nature of the objection, and I think it was raised in light of the items reflected in that in the respondent's memorandum of law. My thoughts on this would be, again, that there should be a limited scope of this inquiry to make it clear that it's not permissible to use an election challenge to inquire into the inner workings of opposing political factions, but at the same time, there is some sort of relevant information with regards to this. I, again, suggest that the objection be overruled, and with the proviso that, again, Mr. Piles tread cautiously about going into those areas that I just discussed.
I'll move we overrule.
Second.
Tim Brophy,
Aye.
Lauren Saley Ferry,
Aye.
Karen Stupel.
Question, did you discuss his Republican voting record at that meeting?
At that meeting, no.
As a Republican Party chairman, I know you understand you're not an attorney, but you are familiar with the provisions of the Electoral Code, are you not?
In general, yes.
And you're aware of the provisions that in a primary, in order to get a primary ballot, are you aware that a party has to declare their party affiliation before receiving a primary ballot?
Yes.
And in this particular case, Mr. Munoz, your candidate for Republican State's Attorney, affiliated himself in the March 2020 primary with the Democratic Party, correct?
Yes.
That's all I have.
Mr. Ivick, anything on cross?
Thank you.
Good afternoon, sir.
Good afternoon.
Mr. Pearson, the Republican Party, do they have a candidate on the primary for state's attorney?
No.
It was vacant, correct?
Correct.
No write-in candidate was chosen.
Correct.
There was other vacancies also, correct?
Correct.
Okay. And what are your job as chairperson? One of your jobs is to make sure that there are no vacancies, correct?
Correct.
Okay. The position of state's attorney is a little bit different from the other positions, correct?
Correct.
The qualifications are a little bit different.
Yes.
You have to be a licensed attorney,
Yes.
probably not newly out of law school, correct?
Correct.
A lot of area of law, correct?
Correct.
Again, I'm not going to go into what you said or what you didn't say at a committee meeting, that's private. But you fully discussed all the possible candidates to fill that vacancy for state's attorney, correct?
Different meetings, yes.
Okay. And you properly notified the select committee, correct?
Majority of them, yes.
Okay. And at that meeting, there was a decision to vote upon Mr. Munoz's candidacy, correct?
Correct.
And he was selected to fill that vacancy, correct?
Correct.
And you said it was unanimous.
Correct.
With, the legal basis of this was 761, correct?
Correct.
Objection to what the legal basis is, unless Mr. Pearson's an attorney. I did not ask him about any code sections, it's beyond the scope, and it's asking for a legal conclusion.
Mr. Ivick, any response before I explain the concepts behind Mr.
Sure. He asked Mr. Pearson if he's generally familiar with the law. Okay? Just asking the same question. If he doesn't know, I'm sure he'll say, I have no idea what you're talking about.
So Mr. Piles' objection, just for the board's edification, is basically, correct me if I'm wrong, because there were a few of them there, arguing that it goes beyond the scope, which we had previously discussed, beyond the scope of his direct examination. Their follow-up to that is also that Mr. Pearson is not an attorney and that he's being asked a question of legal opinion. Generally speaking, I would say I think that there was a discussion as to whether he was familiar with the Electoral Code, which I believe is correct and would be within the scope. As to whether or not as to Mr. Ivick asking Mr. Pearson what he thinks the Electoral Code to be, I think that's a fair question. I don't know that that was quite what was asked. My thought on it would be that it would go towards the weight of I want to assign to Mr. Pearson's lay opinion on what he believes the Electoral Code to be as a layperson, but that he's not an attorney, he's not able to give a legal conclusion. So based upon that, I would suggest that the board overrule the objection as to scope, but sustain the objection as to the form of the question, and that it seeks a legal opinion. Mr. Ivick will rephrase his question to seek a lay opinion or to seek his opinion as what he believes it to be as a layperson. I think that's a different question.
I can rephrase it. Is your lay opinion that there's a statutory basis in 761 for you to fill in a vacancy?
Yes.
And sir, you did that not just for Mr. Munoz, but for the other vacancies on that,
Yes.
from the primary?
Yes.
Okay, and then after that vote, you then had nominating petitions, correct?
Yes.
And with COVID, that was kind of difficult to get a lot of primary voters, I would suspect, correct?
I object, this is beyond the scope. I mean, if he was objecting to what the process is, about getting voter, It's beyond the scope of what I was asking them about. It's very limited when I asked.
And so your objection, just so I understand, is scope, not relevance?
And relevance.
So, Mr. Ivick, any response?
It's within the scope, it is relevant, and we're going to be here all day.
I guess my thought is, I think it's probably within the scope, but I struggle to see the relevance of the question. Whether or not it was difficult to obtain petition signatures doesn't really bear on the merits of this case. That's neither here nor there in my mind. I would suggest the board sustain the objection as to relevance and overrule it as to scope.
Move to sustain.
I second. Tim Brophy,
Aye.
Lauren Staley Ferry,
Aye.
Karen Stupel,
Motion carries.
You know how many votes you had to get? How many signatures you had to get?
Same
Yes.
objection.
Again, I don't see how the number of signatures required to be obtained makes it any more or less relevant, Mr. Ivick. Do you have anything that
The fact that primary voters of the Republican Party, it's not just Mr. Pearson's candidate. It's not that committee's candidate. Over 1,000 primary Republican voters chose Mr. Munoz. That is a fact that is relevant. That's a fact that they want to disenfranchise those people. He has direct knowledge of the process. They got the signatures. They filed it according to statute.
I mean, it just comes back to me, Mr. Childs isn't challenging those signatures. As you said, it's a limited scope objection. I don't understand the relevance of going into the signatures. I would advise, based upon that the board overrule the objection.
Move to overrule.
Second.
Tim Brophy,
Aye.
Lauren Staley Ferry,
Aye.
Karen Stupel,
So they overruled the objection. You may answer.
Yes.
Okay. How many signatures did you get?
Same objection.
They just overruled you, Scott.
It's a different question. I don't understand what the number of petition signatures has to do with the objection. You know, I got objected to just because I was talking about the meeting. Now he's talking about the process of getting the petition signatures. I'm failing to see why it's good for the goose, it's not good for the gander.
Counsel, you've got into the record that the petition signatures were obtained. He's not challenging the petition signatures. I'd advise the board to sustain the objection on this case, and that counsel may want to find a way.
Move to
Sustain.
Second.
Tim Brophy,
Aye.
Lauren Staley Ferry,
Aye.
Karen Stupel,
Aye. Motion carries.
Mr. Pearson, what was the date of the meeting was when?
The selection
The
meeting,
selection meeting?
it was May 26th.
Okay. And in the following 75 days, petitions were passed, correct?
Yes.
Requisite number of signatures, whatever the number happens to be, were obtained.
Yes.
And what did you do next?
We got together with council, completed the nomination and resolution packets, counted the petition sheets, numbered the petition seats, and submitted 2 different packs to the county clerk's office.
Okay, that would have been on June 1st?
Yes.
And when you say "we," who is the "we" that we refer to?
Members of my executive team and myself.
Okay. And then who went to file the statement of candidacies?
Judy Wooten, our elected secretary, Ed Ronkowski, our general counsel, and myself.
Okay. The individual candidates, they weren't there filing, correct?
Following, no.
And so you had the results of the selection.
Yes.
You had the petition signatures.
Yes.
You had the statement of candidacy.
Yes.
Was there anything else that was with when you filed it?
The nomination and resolution.
Okay. And when you got there, what time did you get there?
Objection. This is beyond the scope of anything I asked him about. He's going to call him as a witness and go into all this that's not even relevant. It's beyond the scope, it's not relevant to the objection.
Mr. Ivick?
Just trying to tell the story, Judge, or
Yeah.
trying to tell the story, trying to get this done. I'm sure we all want to go home and finish it.
Mr. Ivick, I don't see how, I think we're getting far afield in the issue, as you keep pointing out. I would suggest that the board sustain the relevance objection as to that question.
I move to sustain.
Second.
Tim Brophy,
Aye.
Lauren Sanford,
Aye.
Karen Stufel, aye. Motion
Whatever the time happened to have been, you filed it, correct?
Correct.
And it was accepted by the clerk, correct?
Correct.
It wasn't rejected.
No.
Sir, you had a chance to review Mr. Munoz's statement of candidacy, correct?
Yes.
And where it asserts that he is a qualified voter of the Republican Party, correct?
Yes.
You were satisfied with that, correct?
Yes.
The members of your party and of the committee were satisfied with that, correct?
Yes.
The Will County primary voters were satisfied with that, correct?
Yes.
And again, Mr. Munoz isn't a new person to the Will County community, correct?
No.
He's practiced law here for well over 20 years, correct?
Objection. I understand he wants to get a narrative and a story, but it's beyond anything I asked. He wants to call him as a witness and get into Mr. Munoz's life history. I didn't ask him any questions about this.
I'll just note, counsel did ask Mr. Pearson about whether he discussed the qualifications of the witness, so I think that counsel...
All right, based on that, I'll withdraw.
You can answer the question, sir. Do you need it repeated?
Yes.
Can you please read the question?
Question, he's practiced law here for well over 20 years, correct?
Correct.
So, Mr. Munoz, did he come to you and ask, I want to run, or did the committee and you go to him?
I went to him.
And sir, I know that there's this objection here. If it's sustained, then presumably the Republican Party would have a vacant candidate, correct?
Correct.
Election's coming up pretty soon, isn't it?
Yes.
That's why Mr. Munoz was even selected, right?
One of the reasons, yes.
No further questions.
Miles, anything on redirect?
Just when you discuss with your committee, as asked by Mr. Ivick, one of the statements on the statement of candidacy, you are a qualified voter of the Republican Party. Is that correct?
Yes.
And at the time that you recruited Mr. Munoz, he was not a qualified voter of the Republican Party, was he? He affiliated with the Democratic Party in the March 2020 election. Isn't that true?
Objection. Counsel is stating false and discredited legal theory that ultimately this board will decide whether that's the law or not. And if he wants to say something that's not the law, I think it's not proper.
Just briefly, the board will give me a little bit of latitude. I'm going to suggest that both counsel perhaps take a deep breath and take a little bit of a step back. And remember that we are all, many of us here are members of a cordial legal profession, and that certain requirements of courtesy and decorum should be obtained in making objections. And that goes for both counsel. That being said, I think the objection, as I recall it, Mr. Ivick, was that somewhat akin to a previous objection made by Mr. Piles, which is that it misstates settled law in the question. Is that the objection?
Correct.
I think what the law is and whether it's settled is a decision for this board to make. So I don't think that that's an appropriate objection to sustain at this time. But I do think that, again, it's important to remind counsel that this is while an informal legal proceeding, still a legal proceeding. and that everyone behaved with the best intentions of the profession in mind. So I would suggest that you overrule that objection because I don't believe it's properly made at this time.
Move to overrule.
Second. Tim Brophy.
Aye.
Lauren Staley Fair. Aye. Karen Stubble. Aye.
Question, and at the time that you recruited Mr. Munoz, he was not a qualified voter of the Republican Party, was he? He affiliated with the Democratic Party in the March 2020 election. Isn't that true?
Sir,
In the general, he's allowed to be able to vote Republican.
move to strike that is non-responsive to my question. I ask that the witness answer the question as presented.
Just to explain to the board, Mr. Piles has moved to strike Mr. Pearson's response. What that means is that Mr. Piles feels that Mr. Pearson's response is not responsive to the question that Mr. Piles asked. He asked it to be stricken from the record, which means that it's a nullity, and that the board admonish Mr. Pearson to answer the question, which means the board order Mr. Pearson to answer the question. The board should rule on that motion to strike by a vote. My thoughts on the motion to strike are that the answer was non-responsive and that Mr. Pearson should be directed by the board to answer the question.
Briefly, if you ask a non-lawyer a legal conclusion and you don't like his answer, that doesn't make any sense.
So I would, it's, again, bearing in mind what Mr. Ivey said, it's my advice to the board that you sustain the motion to strike that testimony, that line of testimony.
Move to sustain the motion to strike.
Second. Second. Tim Brophy.
Aye.
Lauren Staley Fair. Aye. Karen Stubble. Aye. Motion carries.
Remember the question, Mr. Pearson?
Of course I do, Mr. Piles.
Can I have the answer, please?
The answer does not change. At the time when I went to him, he had already voted Democrat, and he would be available to vote Republican in the general.
He'd be available to vote?
He would be eligible to vote as a Republican and vote for any Republican in the general election that he so chooses. You do realize that during that time period that you're allowed to switch.
Is that the basis that you use to put Mr. Munoz on your slate?
I actually use 761 as my basis.
I don't have anything else.
No further questions.
Okay. Is there any other witnesses that anyone's planning on calling Mr. Ivey?
I don't have anything else. I just want to have my exhibits. I think Mr. Munoz has acknowledged that he voted in the Democratic primary, and he acknowledges that's his statement of candidacy. I think my exhibits that were attached to my petition, the certified records, are been admitted by the board. I ask that all those exhibits be admitted, and then I rest.
So I believe we're A through W on exhibits right now, Mr. Ivey. I think you had the last one, was exhibit W.
Correct.
Any objection to those records being admitted and made part of the record?
No objection.
Okay, in that case, the scheduled exhibits will reflect. Mr. Piles has no more witnesses. Mr. Ivey, do you have any witnesses?
I've accomplished everything that I need on the cross. I have no more witnesses. I think it's just legal argument.
I believe you're correct. I think the board can excuse Mr. Pearson. And is our council ready to resolve this hearing and argument on this afternoon? So 5-minute recess would be in order, I think, if the board wishes.
Okay, we'll take a 5-minute recess.
Is that okay, declaration by the chair, or do you want to vote on that?
Yeah, if you could just vote on it.
Move to recess for 5 minutes.
I second.
Wait, hold on. Okay.
I second. Tim Brophy.
Aye.
Lauren Staley Fair.
Aye.
Karen Stubble. Aye.
Recess for 5 minutes.
I'm going to run, pay up my part. parking meter. So I should be back shortly.
You gotta go get that meter. Like a smoke.
So you know, I read one of your papers, get the spellings of the cited cases. I just helped one time.
Anything that you need, you let me know. I'm more than willing to accommodate.
Thank you, bye.
She's worried about my. I need a little space heater under here for my toes.
He's gonna be wild.
Parking meter, so I'm gonna stretch at least.
Not for months. So between the two of you, you have 48 years of service, right?
Since 1975.
Okay, so 45. Mr. Piles, how many years do you have?
I think 30.
75 years. Be a lot matched.
Here's Mr. Pearson's line. I'm not just the election codes of Paul.
You know, she's one of my favorites. Is she still around or?
Well,
I haven't been.
as of month.
How old is she? She's probably. Staff for Rose, I was up on, garden. And like, went out to everything was like, and one of the things I always do is there anything left in the job? She couldn't come. She looks at this guy, and she had these claws like a bird, right? And she looked kind of a little bit dangerous. Yeah, and she's like, yeah, tell the judge, I'm gonna punch you in the nose. Everything else must confuse me.
Just before the COVID stuff hit, the league guy had moved her to.
Well, that was a bad place. They had a lot of deaths in that place.
Right.
That was actually a good move.
Yeah, it turned out it was a lucky move because it was just before the league all came to light.
They do it for their own convenience, or they know something about.
The GA often, Guardian just was not getting funds. Simply, they're probably curious. Nothing, I don't think there's anything with COVID, just it's
since then. Well, that's where I'm going to check your phone.
I think she's still alive.
That's been 15 years. 10 years, at least 10. Yeah.
Yeah, she gets very sense of humor.
Well, I think she really wanted to punch me in the nose. She was joking.
I think she's better than the kind of person.
I was so surprised when she said it. Sit down. And, just ready to tell you what's going on. Questions, say what you say. And I told her that.
Yeah, we've got too much sanitizer on my hands. Just so you guys know, that storm's gonna hit when we all walk out of here.
And not a single prosecutor anywhere wants to do anything with
Then we talk about gun violence, but they attribute to it.
it. And then they fight us to hide it.
Right.
Everybody ready? Okay. We'll go ahead and reconvene the hearing. Council ready to proceed?
I'm ready. Is all the council ready? Okay. So this begins the period of time set forth in our rules as argument by council on the matters. The proofs have been closed. So we're into the phase of argument. The objector will present any arguments he wishes in support of the contention that the candidate is ineligible to run as a candidate for the Republican Party in November 3rd, 2020 general election due to the candidate voting in the March 17th, 2020 Democratic Party primary election. Thereafter, the candidate will have an opportunity To present any arguments in opposition, the objector will then have a chance to reply to those arguments. Mr. Piles.
Just before we start, I'm going to reserve whatever I don't use initially, I'm reserving for rebuttal. And I've got my timer on, so. Madam Chairperson, members of the board, my name is Scott Piles. I again represent the objector, Richard Girard, who, by the way, out of both the parties in this case, is the only Republican voter that's here. Let me repeat that. The objector is the only person that voted a Republican ballot in the 2020 primary. I'm going to read the applicable statute. A person who voted the ballot of an established political party at a general primary election may not file a statement of candidacy as a candidate of a different established political party for a partisan office to be filled at the general election immediately following the primary for which the person voted the ballot. This is the statute, this is the election code provision that applies. There's no room for interpretation here. It's clear. If you want to look at all the different statutory legislative histories, they all say the same thing. You can't party switch in the same cycle. Period. I don't have to make a lot of argument here. The statute is clear. The case law is clear. The legislative history is you cannot switch parties in the same cycle. He voted a Democratic primary ballot. He cannot run for a different established political party. Read respondent's brief. He says 7-61, if 743 was supposed to limit what the political committees can do and the candidates can do in the general election, it should have been in 761. The problem with that argument is that the provisions of 7-43 don't apply to just people to run as established different political parties. They also can't run as an independent candidate. And in 7-61, there's no application for an independent candidate. This language would not apply to what goes on in 761 because 743 deals with the qualifications of primary voters and restricts the ability of a primary voter to run in a different established political party or as an independent candidate. This section doesn't belong there. It doesn't belong in 761. And as questioning with Mr. Munoz indicated, he admitted that to take the qualifications of a person, you're going to take it from different parts of the election code. You have to file a statement of candidacy under 7-10. You have to be an attorney. It's required by the Illinois Constitution in Article 6. You have to be a legal voter, 30 days. Very simple. And that's pulled from all different parts. He quoted some Latin, expresso something. The thing that applies here is in peri materia. You read the act as a whole. You can't just isolate 7-61. What should concern this electoral board in this particular case is from the testimony of the witnesses here. You have the Republican Party chairman that hold it, and they make a big deal in their statement of candidacy. They change the form from the state form. And they talked about, well, the statement of candidacy, he's a lawyer, so we had to redraft it. Now, it doesn't fly here because in the statement of candidacy, it indicates that that a person has any, and I'm going to quote, including being the holder of any license that may be an eligibility requirement for the office that I seek election. That's in the statement of candidacy found Mr. Buder. So the fact that he's an attorney, that's not why they drafted this. What they drafted this statute or statement of candidacy for is to commit a fraud. And you want to know how they evidenced it? It was admitted by the Republican chair. He didn't tell his people that voted in this slating meeting that they were selecting a Democrat, that he affiliated with the Democratic Party in the March primary. I asked him point blank, did you tell them at that meeting? He said no, and then they voted. That should cause pause here. Mr. Munoz was also aware of the requirements of 7-43, and he signed a statement under oath stating that he was a qualified voter of the Republican Party. They quite qualified in the statement, as evidenced by being designated, selected by, appointed by a duly convened Will County Republican Central Committee. Except the Central Committee weren't told that they weren't having a qualified voter of the Republican Party as their candidate. They weren't told that. Mr. Pearson admitted that. Mr. Pearson admitted he did not tell these people before they voted in this meeting that they were slating a Democrat. A Democrat, by the way, that under 7-43 is ineligible to run. You're going to see a lot of flag waving, ballot access. Oh, we're not going to have a choice. I'm going to submit to you that knowing partisan precinct committee people, in my experience, I don't think you would have had a unanimous vote if Mr. Pearson had told his committee people that they were slating a Democrat. A Democrat that was ineligible to run in the general election. And just so we don't get lost in the weeds here, the only time after you voted in a primary that you could possibly file a statement candidacy for an established political party is when you're filling a vacancy. To argue that 7-43, the limitation on people that vote in primaries, doesn't apply to this, would render this language nullified. It would be an absurd interpretation of the statute and would nullify it from having anything. We had some discussion about this Hausfeld case. Hausfeld supports our position. It says that the Cullerton case, which we rely on and which Hausfeld relies on, is different from the facts regarding Mr. Rauschenberger. And counsel will explain that to you. That was a consolidated election that happened in the spring. As clear from the legislative history in the briefs that have been filed, it's the primary and the general election are bundled together. You can wave as many flags and create as much dust as you want. They cannot get around this statutory qualification. This objection should be sustained. Thank you.
Mr.
And
Ryan.
I have 7:22, so I have seven minutes and
Some odd seconds.
yes.
Mr. Piles, members of the board, members of the audience. It's a bizarre, polarized world we live in. And up is down, black is white. And as an attorney, it's my profession that's probably mostly at fault. It strikes me as just bizarre that the only Republican here doesn't want the Republicans to have a voice. That should strike you as bizarre, too. That they should be disenfranchised. It wasn't Mr. Munoz who decided to run for state's attorney. He said on oath that when he pulled that ballot, he had no intention. He was just, voting. His primary voter, the designation said it's for the primary only. Mr. Files quotes the law. He likes to quote the law. Unfortunately, he quotes parts of the law. 743, again, above the part he doesn't quote is that the following regulations shall be applicable to primaries. Doesn't say general elections. And then it leads to a question. Why? Why is that there? Why is that sore loser law there? Why has it changed? What does it mean now? What are we doing here? One of the first and most important rules of statutory construction, because that's what we're here about. He's trying to confuse the issue when he states that the Republican Party was confused. No, we weren't confused. The issue is whether or not Mr. Munoz, having voted in the Democratic primary, can he be selected to be the Republicans' choice in this election? That's the only issue before this court. He says in his brief, this is the sole issue. To the extent he argues anything else, he's trying to hide them all. And we, attorneys, we do that, and that's why we have a bad reputation. But let's try and be brief. Let's go right to the point. What is being asked of this board? The board is being asked to throw Mr. Munoz off the ballot. The board is being asked to deny the Republican Party their right to field a candidate. The board is asking you, Mr. Piles is asking this board to deny the ability of all the Republican primary voters who signed the petition to disenfranchise their ability to select a candidate of their choice, not Mr. Girard's choice. I know that he may not be happy with the fact that the Republicans found an attorney that's worthy of standing up for this election, but it's not his choice. It's the choice of the Republican Party. It's the choice of the Republican primary voters. And I suggest to you, the relevant law starts at 761. When you read 761, you can't read it in a vacuum. I agree. All the election laws apply. All of them apply until they don't. That's how it always is. Sometimes you apply part of the law, sometimes you don't. You first look at the clear language, and so does 761 have any prohibition against someone voting and then running? Answer to that is absolutely not. 761 has two restrictions. The restriction is if the person ran in another party or caucus. Other than that, it doesn't say that you couldn't have been a voter, that you couldn't have signed a petition. Why is that important? Why is it important that they listed a restriction but then didn't? Mr. Piles referred to my brief, the Latin, and again, forgive me, expressio unius est exclusio alturius, in English, that when a statute is construed and it has a enumerated exception, when there's a listed exception in a statute, it excludes all other exceptions. For example, let's say you can't go to the park if you're wearing blue, red, and yellow. Everyone knows that. You can't go to the park wearing blue, red, and yellow. Okay? If there's another section of the law that says you can't go to the park wearing blue, and they don't list the other exceptions, then those other exceptions do not apply. Very basic statutory interpretive skill. I think the question that Mr. Piles raised is, well, are there other things that apply? Sure, there's other things that apply. He has to be a voter. He has to have a law degree. We're not saying that. Okay, but the question is, are we going to throw him off the ballot? There is another rule of construction. The other rule of construction is, what is the intent? What is the intent? What is the purpose of the laws that you're trying to interpret? Well, the intent of the voter laws in general is stated by the court in Carlisle versus Will County Officers Electoral Board. The primary purpose of all election laws is to ensure a fair and honest election. The policy of this state is to provide candidates for public office with access to ballots and thus allow citizens to vote. And this was interpreting 761. Primary purpose is to provide ballots to candidates and allow people to vote. Up is down, black and white. If you take their position, your result would be not a candidate for anyone to vote for. You'd be violating the primary purpose. Carlisle is very informative for how to interpret this objection. It is informative because, like our case, there was vacancies in the ballot. Democrats had a whole bunch of vacancies for board. And they slated all these candidates, and Republicans objected to it because they didn't follow the proper process in all the election laws. The committees weren't properly formed. The notice that's required in the election laws wasn't followed exactly the way it's supposed to be. The court examined that argument, and they said, if you do that, there's no one running. If you do that, you violate the first principle, ballot access and allowing people a choice. And so how did the court resolve that? Well, they looked specifically to 761, and they said 761 doesn't have that requirement for the constitution of the committee. 761 doesn't have that requirement for that type of notice. Good enough. We're not going to do harm to the overall intent by reading into 761 requirements that aren't there. And that's exactly where we are today. The objector would have you read into 761 requirements that aren't there. Historically, and I said historically because it's important to know in interpreting what the law is today. Historically, there was 3 reasons why you couldn't run a candidate. That they voted, that they signed a petition, or that they ran. Just before 743 was modified, the Supreme Court in Hausfeld examined it. And they talked about what a qualified primary voter is, and they said it has to be the same election cycle. But then this language, which is so important, they say, the only remaining restriction set forth in both 710 and 88 is that a qualified primary elector of a party may not sign petitions for or be a candidate in the primary of more than one party. Nothing about voting. On the primary ballot he pulled, it said this is for the primary only. So Hausfeld said there was only 2 more restrictions left. Now when you look at the statutes, it goes down to 1. You can't run in it. And again, the legislature, every single word matters. If they would have left no restrictions in 761, if they would have said they were silent, maybe you could make the argument that you would apply 43. They spoke. And when they spoke, and this is 761, this is why we're here. This is why the Republican Party has the authority to do this. A candidate for whom a nomination paper has been filed as a partisan candidate as a primary election and who is defeated on his or her nomination of such primary is ineligible to be listed on the ballot of that general or consolidated election as a candidate for another party. Mr. Munoz was not a candidate for the Democratic Party or any other party in the primary. He didn't even know that he was going to be selected. There is 1 restriction. Where are the other 2? Why do they put that 1 restriction in, but not the other 2? Why? Because it is more important that the people have a choice than we leave the ballot vacant. We don't have the type of country where our democracy is we vote for 1 choice. That's what the Republican Mr. Garrett wants. You only have 1 choice, 1 flavor. You can have vanilla. No, we gave you a choice, vanilla. 761 was specifically there to stop that. That's what the case law says, that it is so important that we provide access that when there is a vacancy, we allow a different way to do this. This wasn't Rick Munoz by himself voting or deciding, I'm going to run for office. This was the Republican Party with a vacancy from their primary, properly selecting, properly voting on, properly passing petitions. Over 1,000 Republican primary voters chose Mr. Munoz. Their reading of the law would disenfranchise them. Their signatures are meaningless. Mr. Girard doesn't have to vote for Mr. Munoz if he has a problem with him. He's free to do whatever he wants. But he can't disenfranchise every other person in this county. No one will have a choice. And again, it is ironic that they're here saying follow all the election laws. Yeah, you have to follow them. And the Republican Party did follow them. They made their choice. And you can't read into 761 a restriction that's not there. As far as for the legislative intent, we both cited in our briefs. I thought it was interesting that there was a difference in opinion. On the House, they said specifically, we're not making new law. We're just saying what the law is. That's probably why they put that restriction under a paragraph that said only to primaries. Probably. It wasn't their intent to make new law, but even if they would, the Supreme Court said there was only 2 valid restrictions allowable. The 2 valid restrictions, if you ran in the other party or if you signed the nominating petition. That isn't here. The statute says he can't have been another party candidate. He wasn't. The clear reading of the statute, the language of Carlisle, where they don't allow this novel idea, we're going to read in the whole thing to the point that we do harm to the intent. How do you answer the fact that when the people in Will County go to vote November, there's only one choice? Why is that? Oh, we're making the choice for you. Let them vote. Give them that right. Follow the law. This objection is not well-founded, not in law, not in fact, and it's disingenuous to say he's the only Republican here. Well, there is 1,000 Republican primary petitioners who want a voice. They're asking you to disregard them. They have the right to choose. The Republican Party has the right to choose. And we pray that you give the people, the citizens of Will County, the right to choose.
$743 doesn't apply, it only applies to primaries. That's an interesting interpretation of this statute. A person who voted the ballot of an established political party, in this case Mr. Munoz voted a Democrat as a primary, and says after that occurred, after that primary ballot was pulled and the primary election is held, that person may not file a statement of candidacy as a candidate of a different established political party for a partisan office to be filled at the general election. Immediately following the general primary for which that person voted the ballot. I don't understand his argument. I can read. How does the statute not apply in this circumstance? We're not talking about somebody being denied the right to run for office. Mr. Munoz decided to affiliate with the Democratic Party in the primary. He felt that way. His choice was to run in the primary against Mr. Glasgow. Didn't make that choice. He had that opportunity. He pulled the Democratic ballot. Now, you follow the Republicans' argument here, and he's citing my Colasari case. And the thing, and the first line is this: the laws, the election code is to allow for honest and fair elections. And what was done with the statement of candidacy here? Under oath, Mr. Munoz stated, "I am a qualified voter of the Republican Party." Your counsel is going to tell you what that means. And what it means is qualified. It's plenty. What does the 743 say? Qualifications of voters at primary elections. I am a qualified voter of the Republican Party. Except when he voted in the primary, under the section where it talks about qualifications of voters, he pulled a Democratic ballot. I don't understand this argument. He's essentially asking the board to not read the statute. Instead, we'll want to wave the flag and say, well, people are being denied. I'm going to make a suggestion here. I don't think you're denying these folks their candidate because they were not told what they were getting when they voted for him either at the committee And they weren't being told when they were signing these petitions that they were signing on behalf of a guy that pulled the Democratic ballot in the March primary. It's interesting to say, I asked Mr. Pearson during this, did you tell these people? And he said at this meeting, no, I did not tell them that he voted in the Democratic primary. And he was specific with his answer. Now maybe a follow-up should have been by his counsel, well, did you tell these people that he was a Democrat at some other point? He didn't ask that question. What are we left with? So the people that slated this guy, they weren't told that he was a Democrat. They affiliated with the Democratic Party in the March primary. How do they try to backfill this? So Mr. Ronkowski's, he's smart. You got a Democrat. Well, we could turn him into a Republican by saying that, as evidenced by being designated, selected by an appointed, duly convened Republican Party Central Committee. With the stroke of George Pearson's pen, we can turn somebody that voted Democrat into somebody Republican in a matter of a couple of months. Throw out the election code, throw out the statutes, disregard all that. If Mr. Pearson says so, it's okay. That's not what the law is. And I'm suggesting to you that they violate the first principle of fair and honest elections where they don't tell the people that were voting to slate this guy, hey, by the way, he voted in the 2020 Democratic primary. He's affiliated with the Democratic Party. I can tell you, if I had pulled something like that when I was party chair, it wouldn't have flown. No way. But that's not what was done here. Instead, we try to rebore the client or the candidate into a Republican just because people that were not informed that he voted in the Democratic primary and were told that before he voted. Honest? That's a question for the board. I think they violate that first rule. These folks did not know, so you can flag wave and you can all talk about petition signatures all you want. Mr. Munoz is a Democrat. If he wanted to run for state's attorney, he could have run in the Democratic primary. Instead, he chose to vote in the Democratic primary. You cannot switch parties in the same cycle. I don't know how more clear this can possibly be. Now, I asked questions of Mr. Munoz, and he says, well, if we just limit this, our argument is 761 controls the whole thing. All the qualifications are in there. Problem is, they're not all in there. There's lots of them. You have to be a qualified voter of your party. That's not really in there. You have to be a resident, and you've got to have a license, at least in this case. Those qualifications are not found in 761. They're found in other parts of the election code, just like 743 is. I'm confident that your board counsel is going to essentially tell you to read section 7-43 as it's been read and apply it. And do not allow a Democrat to be disguised as a Republican for the 2020 general election. Thank you.
That concludes the arguments of council. This is typically the time when the board could ask any clarification questions they may have of council. If no one on the board does, I do have a question that if the board will give me leave, I'd like to make an inquiry on. My question's for Mr. Ivik. In reviewing the memorandums of law that were submitted, objectors' petition or objectors' memorandum cites section 7-1 of the Electoral Code, and it says that except as otherwise provided in this article, a nomination for all candidates for state's attorneys, which there's a list of other candidates there too, shall be made in a manner provided in Article 7 and not otherwise. Your argument to me seems to be predicated on the, basically a contrary reading of that. How do you distinguish your argument from the requirements of 7-1?
I think Carlisle speaks to that. I think to read it any other way, you would have to do two things. You'd have to do harm to the language of 761. You have conflict. You have 743, which says only for primaries, and then it has restrictions, which says you can't vote, you can't sign the nominating petitions, or you can't run. So it says that under that paragraph. In 761, it lists the restrictions, but it only lists the one. There is a conflict. How do we resolve this conflict? Okay? Well, the way you resolve the conflict is you understand that when a legislature speaks and they list one to the exclusion of all the other two that they know about, for this particular reason, they don't want those restrictions to apply. Otherwise, they would have spoken, said clearly, all three. And perhaps the reason is that it's such a grave harm to our society to have a vacancy that when a major party doesn't even field a candidate, 761 relaxes that. They relax that so that we have a choice. Okay? And so I think to say that, well, just because other things apply, not if it's going to completely disenfranchise everyone. And I think, again, the Carlisle argument, I think, is right on point. The argument was that the party didn't properly convene the committee. And yeah, the appellate court said, or the circuit court, the board said, yeah, you didn't properly convene the committee. They said you didn't give the proper notice. Yeah, the circuit court and the board said you didn't give proper notice. And on appeal, Carlisle goes to the bigger issue. The bigger issue is, why are we here? Why don't we have the right to vote? 761 is guaranteeing that. They wouldn't read into 761 something that would have the result of disenfranchising everyone. And so, again, in answer to that, it's not that the whole section doesn't apply, but there is a conflict. You have to acknowledge that there's a conflict because in 761, it lists only one of the three restrictions. And so you can't read into restrictions. You know, my Latin, while it's not as good as Mr. Pyle's, is still how you interpret law. That if there is one restriction to the exclusion of the other ones, you can't add those other restrictions. And so, again, I think if you do so, you wind up with a result that is contrary to the principles of valid access, contrary to the principles that we give parties, major parties, special powers there to select someone. And it's their selection, not Mr. Munoz's selection, not Mr. Gerard's selection. It's their selection and it's their primary voter selection that we are respecting here.
Thank you for your response to my question. Unless there are any other questions from the board?
Just a clarification question. Where Mr. Piles refers to Carlasari and Mr. Eidert refers to Carlisle, I think those are one and the same. Okay, so for the record, Carlisle is Carlasari.
Oh, there's a name, Carlisle.
Okay.
Just for the court reporter's sanity.
C-A-R-L-A-S-A-R-E.
Thank you. That concludes the argument on this matter.
No other questions, Madam Chair.
Mr. McCarthy, could you please provide the electoral board with your legal opinion on whether the candidate is eligible to run as a candidate for the Republican Party in the November 3rd, 2020 general election?
This matter turns on the interpretation of three sections of the election code. Sections 7-10, 7-43, and 7-61 respectively. Section 7-61 provides for the appointment of candidates to fill a vacancy. As part of that appointment process, Section 7-61 provides that a resolution to fill a vacancy in the nomination must be accompanied by a statement of candidacy as set forth in Section 7-10. As part of that statement of candidacy, the candidate was required to affirm, among other things, that the candidate is a, quote, qualified primary elector, close quote, of the party to which the nominating paper relates. Section 7-43 of the Election Code provides that a person who voted the ballot of an established political party at a general primary election may not file a statement of candidacy as a candidate for a different established political party or as an independent candidate for a partisan office to be filled at the general election immediately following the general primary for which the person filed the statement or voted the ballot. The parties differ on how these three sections should be interpreted and how the statutes interact. Objector argues that the requirements of all of Section 7 apply to any given candidate's nomination papers, except where they're expressly excluded. Therefore, simply because candidate is seeking to file his nomination papers pursuant to Section 7-61, he must still comply with the requirements of Section 7-43 and therefore 7-10. In support of this assertion, Objector's Memorandum of Law cites Section 7-1 of the Election Code, which states that, in pertinent part, except as otherwise provided in this article, the nomination for all candidates for state's attorneys shall be made in the manner provided in this article and not otherwise. Objector asserts that Article 7 basically isn't applicable to all candidates unless it's expressly excluded. The objector asserts that it makes the language applicable to all candidates unless it's expressly excluded. The candidate's defense to this objection turns to the application of Article 7 of the Election Code to the nomination of candidates to run in the November 3rd, 2020 general election. The candidate's Memorandum of Law did not address Section 7-1 of the Electoral Code. That's why I made an inquiry of him. And his argument seems to be that Section 7-1 doesn't matter. What matters is the overarching principles regarding election law, and that was to ensure a fair and honest election and to provide ballot access. Candidate further argues that the provisions of Section 7-43 are expressly limited to persons. Therefore, the intent of the legislature was to distinguish between nominating papers submitted by an individual candidate, which would be required under 7-43, and those submitted by a committee, which candidate's Memorandum of Law purports to be limited in Section 7-61. It's my opinion that candidate misapprehends the law. Section 7-1 of the Election Code expressly states that the nomination for all candidates for state's attorneys shall take place only in the manner provided for in Article 7, which is entitled The Making of Nominations by Political Parties. The Election Code provides as part of 7-61 that a statement of candidacy must be filed. Section 7-10 governs the requirements of a statement of candidacy, and that statement of candidacy is a personal attestation by an individual, to wit, the candidate. It must affirm under oath that he is a qualified primary voter of the party for which he seeks to run as a candidate. The Election Code provides that requirement in Section 7-43, wherein it stated, a person who voted the ballot for an established political party at the general primary election may not file a statement of candidacy as a candidate for a different established political party or as an independent candidate for a partisan office to be filled at the general election immediately following the general primary for which the person filed the statement or voted the ballot. In support of this interpretation, candidate cites Hosfield, H-O-S-S-F-I-E-L-D, versus Illinois State Board of Elections in an attempt to distinguish Cullerton, C-U-L-L-E-R-T-O-N, versus DuPage County Officers Electoral Board. It's important for the board to understand what these two cases stand for and how they should be interpreted. In Cullerton, the candidate voted a ballot for the March 2008 general primary elections for the Republican Party. The Democratic Party thereafter attempted to select Cullerton as a candidate for the November 2008 general election pursuant to Section 7-61 of the Election Code. The objector filed a petition stated that the candidate was not a qualified primary voter of the Democratic Party. These facts exactly parallel the circumstances presented to this board as part of this objection. In Cullerton, the court found that Section 7-43 of the Election Code precluded the candidate from appearing on the ballot. That's different than what the Illinois Supreme Court encountered in Hosfield. The candidate in Hosfield sought to run as a candidate for the Republican Party in the February 2010 general primary election. The objector sought to disqualify a candidate as he had voted a Democratic ballot in the February 2009 consolidated primary election. Hosfield adopts the conclusion in Cullerton. The court in Hosfield notes and quotes Cullerton in stating, "The plain and ordinary meaning of the requirement that a candidate be a qualified primary voter of the party for which he seeks nomination mandates, if nothing else, that the candidate have been eligible to vote in the primary for that party in the most recent primary election preceding the candidate's filing the statement of candidacy." The court distinguished the circumstances it faced from Cullerton by noting that such a prohibition would only apply to the election cycle wherein the candidate sought to run. The Supreme Court also noted that eliminating the express 2-year statutory, quote, "no switching period" in favor of a generic, quote, "qualified primary elector" standard was, quote, "a matter for legislative determination." As part of both parties' memorandums, the attempt to use the floor debates in the General Assembly's passage of House Bill 2009. Candidate seeks to persuade the board using the floor debate from the Illinois House on this particular bill. In his colloquy, and he notes that he did provide, I will point out, candidate and objector provided a very thorough record for review by the board. But in that record, in his colloquy with Representative Will Davis, Representative Fortner, F-O-R-T-N-E-R, the sponsor of House Bill 2009, was asked, "Where someone files and their petitions are challenged and they're kicked off the ballot, does this prohibit them from showing, after the fact, where they get appointed by the political party?" In his reply, Representative Fortner stated, "What this says is that it's the act of filing is treated the same as the act of taking a primary ballot. That's the commitment from the candidate as to what party they want to be associated with for that one election cycle." That statement clearly indicates the legislative intent to prohibit party switching within an election cycle, either by filing a statement of candidacy to run for an office or by voting a primary election ballot for a different party. Additionally, it undermines the candidate's assertion that the legislative intent of the amendment was to provide for a differing outcome where the political party slates that candidate. The objector also references the floor debate on House Bill 2009, though objector addresses the intent of the legislature with regards to the colloquy between Senator Harmon and Senator Reiter, R-I-G-H-T-E-R. In response to Senator Reiter's inquiry as to whether the bill refers to the most recent primary election cycle in which the individual candidate voted, Senator Harmon states, "The bill couples the primary and its associated general in a bundle. It's only your behavior in that primary election that could disqualify you in that general election. Voting in a different partisan primary in a prior election explicit in the bill does not disqualify you." The members of the General Assembly clearly intended to codify the rulings of Cullerton and Hosfield. Additionally, the House sponsor of House Bill 2009, Representative Fortner, summarized the bill stating, "House Bill 2009 will codify some recent court decisions that have dealt with the issue of when it is and when it is not permissible to switch parties. It's a very simple basis that the courts have used, and that's the basis of this bill as well, which is to say, whenever you're between election cycles, whether they be odd year or even year cycles, you are free to switch parties. But once you have committed by voting a particular way in a primary, you're committed to be in that party in terms of what candidacy you may choose to adopt through that cycle." The candidate also argues the board should find the statement of candidacy to be in substantial compliance with the election code. The election code section that governs statements of candidacy contains both mandatory elements and discretionary provisions. The court found that in Aiken v. Smith, A-K-I-N, Smith, S-M-I-T-H, where it stated, "Whether a statute is mandatory or directly depends on the legislature's intent, which is ascertained by examining the nature and object of the statute and the consequences which would result from any given construction. On the one hand, a statute in the election code may generally be given a mandatory construction if it expressly states that failure to act in a manner set out in that statute will void the ballot. On the other, a statute may generally be construed as directory if it simply prescribes performance of certain acts in a specific manner and does not expressly state that compliance is essential to the validity of the ballot. That is, in construing statutory provisions relating to elections, the courts have generally tended to hold directory those requirements as to which the legislature has not clearly indicated a contrary intention, particularly where such requirements do not contribute substantially to the integrity of the election process. And it cites Schwallenstecker, the usual way, SCHWALLENSTECKER versus Rull, R-U-L-L. To the extent that Section 7-10 of the Election Code is mandatory rather than a directory function, the Illinois Supreme Court has acknowledged that substantial compliance can satisfy mandatory statutory requirements governing statements of candidacy. However, substantial compliance with Section 7-10 does not excuse a complete disregard for Section 7-43. The language of Section 7-43 is clear. A person who voted the ballot of an established political party at a general primary election may not file a statement of candidacy as a candidate of a different established political party or as an independent candidate for partisan office to be filled at the general election immediately following the general primary for which the person filed the statement or voted the ballot. This express prohibition is clearly mandatory in nature and is not simply prescribing a punishment, but expressly providing that such a statement of candidacy may not be filed. This prohibition cuts to the very heart of the partisan electoral process, preventing party raiding or party switching and interfering in partisan primaries of the opposite party to which candidate ultimately chooses to run as a candidate. The law on this matter is clear. It's clear in its application, it's clear in its language, and it's clear in its intent. If you find that the candidate voted a Democratic Party ballot in the March 17, 2020 election, then under Section 7-43, he is prohibited from filing a statement of candidacy for any party but that of the Democratic Party for the November 3, 2020 election cycle. This is the law as set forth in Cullerton and Hosfield, which the General Assembly clearly intended to codify by enacting HB 2009, which became Public Act 97-0681 upon being signed by the Governor. The statement of candidacy cannot be found in substantial compliance with Section 7-43, as it is expressly contrary to the mandatory and essential requirements of Section 7-43.
Thank you, Tom. You ready for action?
Based upon the arguments made by the parties and the opinion rendered by the board's attorney, I will entertain a motion to sustain or overrule the objection relative to the candidate's eligibility to run as a candidate for the Republican Party in the November 3rd, 2020 general election.
I move to sustain the objection relative to the candidate being an unqualified voter of the Republican Party at this time.
I second.
A motion has been made and seconded. Is there any discussion?
Just want to be sure that the form of my motion is in order.
Yeah, your motion, as I understand it, is to sustain the objection as to the...
As filed by Mr. Jerome.
Correct.
All in favor of the motion say aye.
Aye.
Aye. Opposed say nay. The motion carries. Okay, that concludes the ruling on the objection raised in the verified objector's petition. Based upon that ruling, the board is prepared to render a decision in this matter. It is the decision of this electoral board that the objection raised be sustained for the reasons stated on the record. Accordingly, the name of Richard Munoz as candidate for the office of Will County State's Attorney shall not appear on the official ballot for the November 3rd, 2020 general election. The written decision of the electoral board will be available on Wednesday, June 24th, 2020 at 1 p.m. in courtroom 121 of the Will County Courthouse. The written decision will be approved and signed by the electoral board at that time. If the parties or their representatives wish to receive the decision by electronic or regular mail, they may complete a waiver and consent form to receive the decision by electronic or regular mail. The waiver and consent must be completed prior to the parties or their representatives leaving today. There is a waiver and consent form available from ASA McCarthy The executed waiver and consent form can be tendered to Assistant State's Attorney McCarthy. I'll entertain a motion to recess this hearing to Wednesday, June 24th at, I think it needs to be later,
Does it need to be later?
Actually.
I'm flexible as to my time whenever the board wants to meet.
1:30. Does 1:30 work on Wednesday? I'll entertain a motion to recess this hearing to Wednesday, June 24th, 2020 at 1:30 p.m. in courtroom 121 of the Will County Courthouse for approval and signing of the written decision of the Electoral Board.
I so move.
Second?
Any discussion? All in favor of the motion, say aye.
Aye.
Aye. Opposed, say nay. The motion carries. Are there any members of the public present who wish to provide public comment?
George Pearson, Chair of the Will County Republican Central Committee. I've sat here and listened to Mr. Piles call me deceptive when his question was actually framed, did I make that statement to my people on that day? And on that date, no, because of the COVID situation, we were kind of pressed for time. It was on a Zoom meeting. It wasn't the typical meeting. What Mr. Piles failed to mention is I was very specific about that time period because prior to that I made phone calls to members of my party. In fact, even had in-person meetings to discuss the fact that Mr. Munoz had pulled a Democrat ballot. So to say that I was defrauding the Republican Party or its electors is a flat-out lie, and I take offense and insult to it. Secondly, when we look at it, we were having problems filling election judges during this time period. We were having problems because of COVID-19, and the clerk's office had went out to find out, even within her own administration, if there were enough Democrats and Republicans to actually sit at the election machines in order to tally the votes. And there wasn't. We had to make special arrangements during that time period in order to see that through. A lot of times in this government, because of how the Republican Party is portrayed, a lot of folks don't like to say what they do. So they either don't pull a ballot at all, which is well over 100,000 voters in Will County alone, that refuse to pull a ballot one way or the other, to refuse or to prevent from being ridiculed, disrespected, or lied upon by members of the Democrat Party. What Mr. Piles also failed to tell you is that his objector was a former Democrat precinct committeeman, ran as the sheriff for the Democrat Party, and now he is considered a Republican. This is a man who, if you honestly want to talk about deception, probably should start with the objector himself. This is a man that was caught up in an investigation as to weapons that came up, disappeared. But this is the only Republican voter that Mr. Piles feels eligible to make a decision on who should run as a Republican. And I also find that insulting and degrading. I hear your vote, and I appreciate your time. But to say that the voters and the Republican side did not receive notification about who Mr. Munoz was is a flat-out lie. And I expect an apology from Mr. Piles. Thank you.
Electoral, F-I-C-A-R-E-L-L-O, resident of Will County. I'm going to read a summary and statement prepared by myself and Ms. Alyssa Benford, who's a
member of the DuPage Township trustee. We both understand that the Illinois Attorney General has an open investigation regarding complaints filed by another elected official regarding the Open Meetings Act of this electoral board. One of the complaints regarding rules being adopted that were not on the agenda. At a second hearing, a member of the audience directed a request to the board to properly add and adopt the rules at the next meeting. Instead of the board properly following the Opening Meetings Act, Conor McCarthy cited a portion of the act that had nothing to do with the electoral board. Mr. McCarthy even mentioned speaking with Sarah Pratt in an effort to give credibility to his statement. The board and the legal counsel should not be biased. Mr. McCarthy failed to disclose to Sarah Pratt that this electoral board has never posted a proper agenda, nor have they approved an agenda at the start of any meeting. To quote Lisa Madigan, previous Attorney General, open and honest government is the cornerstone of American democracy, and it can only be achieved through free exchange of information between the government and the citizens. She goes on further to state that the Illinois Open Meetings Act is designed to prohibit secret deliberations and actions on matters which, due to their potential impact on the public, probably should be discussed in a public forum. Even after receiving notice of the investigation of the Attorney General's office, there was still not an agenda posted timely. The clerk laughed at one point during public comment, and the second hearing, when she was asked to make sure that individuals were able to enter with their phone. This is not an elected matter. Members of this audience should not have to plead to follow the Open Meetings Act. Illinois Attorney General investigative letter dated June 18, 2020 specifically states, please explain if the board took final action to adopt the rules at the June 9th, 2020 meeting, and if it was listed on the agenda. We are at meeting 4 and still no proper agenda for the Open Meetings Act. Melissa Dunford has requested the Attorney General of Illinois Office of Public Access Bureau/Counselor to review and provide an opinion as to the many violations outlined in her correspondence with the PAC pertaining to the June 9th hearing. Mrs. Dunford has provided information to the PAC which demonstrates the lack of compliance with the Illinois statute pertaining to the Open Meetings Act. Thank you for your time.
I got one thing. Pick it up there. John Kraft, K-R-A-F-T. If either the board or the attorney, since you're sitting in for the state's attorney, could ask the Attorney General for an opinion on the election code's statement on a public member being appointed by the chief judge. I would be interested in the Attorney General's opinion on, does that mean somebody that's not appointed to a public office already or elected office being a public member? Or could an office holder also be a public member sitting on the electoral board?
I should be clear, my appointment as special counsel is limited to the issuance of a written opinion in the electoral board case.
I know.
As soon as the written opinion is approved, I turn into a pumpkin, so to speak. I'm nobody different than any other person that's down here. I can't advise the board, and I also don't have the ability as a Will County State Attorney to formally request it, because I haven't been elected to that.
So I will forward an email to you guys and ask you to forward it to your state attorney for an opinion. Thanks.
Any other members of the public wish to speak? Anyone else? Okay,
I move we adjourn the public meeting of the board until Wednesday, June 24th, 2020, in this room. We agreed at 1:30.
yes.
I second.
Okay, motion has been made and seconded. Is there any discussion? Any discussion? All in favor, say aye.
Aye.
Aye. Opposed, say nay. Motion carries. We stand adjourned until Wednesday, June 24th, 2020.